finish that.
That's the only question I have. If it's
running and they're like, oh,
Yeah.
and just stop it to add them.
Yeah. Okay. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare recesses of the committee at any time. The Chair welcomes the members of the audience who are here, but any member who disrupts this meeting will be removed. And presently, we do not have order in the hearing room. Members of the audience must behave in an orderly fashion or else they will be removed from the hearing room. Rule 11 of the House Rules provides that the chairman of the committee may punish breaches of order and decorum by censure and exclusion from the hearing. So if there are members here who wish to remain, they should sit down immediately or leave the room immediately, or they'll be escorted from the room. Today's hearing is about the President's role in our constitutional system. Our system of government is a tripartite one, with each branch having certain defined functions delegated to it by the Constitution. The President is charged with executing the laws, the Congress with writing the laws, and the judiciary with interpreting them. The Obama administration, however, has ignored the Constitution's carefully balanced separation of powers and unilaterally granted itself the extra constitutional authority to amend the laws and to waive or suspend their enforcement. This raw assertion of authority goes well beyond the executive power granted to the President and specifically violates the Constitution's command that the President is to take care that the laws be faithfully executed. The President's encroachment into Congress's sphere of power is not a transgression that should be taken lightly. As English historian Edward Gibbon famously observed regarding the fall of the Roman Empire, the principles of a free constitution are irrevocably lost when the legislative power is dominated by the executive. Although the President's actions may not yet amount to the executive's powers overtaking the legislative power, they are certainly undermining the rule of law that is at the center of our constitutional design. From Obamacare to immigration, the current administration is picking and choosing which laws to enforce. But the Constitution does not confer upon the President the executive authority to disregard the separation of powers by unilaterally waiving, suspending, or revising the laws. It is a bedrock principle of constitutional law that the President must faithfully execute acts of Congress. The President cannot refuse to enforce a law simply because he dislikes it. Certainly, presidents have from time to time made broad claims of executive power. However, assertions of executive authority have traditionally been limited to the area in which presidential powers are at their strongest, foreign affairs. The Obama administration, though, has been equally assertive in the realm of domestic policy, routinely making end runs around Congress through broad claims of prosecutorial discretion and regulatory actions that push executive power beyond all limits. Indeed, President Obama is the first president since Richard Nixon to ignore a duly enacted law simply because he disagrees with it. In place of the checks and balances established by the Constitution, President Obama has proclaimed that, quote, "I refuse to take no for an answer," end quote, and that, quote, "where Congress won't act, I will," end quote. Throughout the Obama presidency, we have seen a pattern. President Obama circumvents Congress when he doesn't get his way. For instance, while Congress is currently debating how to reform our immigration laws, the President effectively enacted the DREAM Act himself by ordering immigration officials to stop enforcing immigration laws against certain unlawful immigrants. When he couldn't get his preferred changes to the No Child Left Behind education law, he unilaterally waived its testing accountability provisions. When he objected to the work requirements in the bipartisan welfare reform law, he granted waivers that are specifically forbidden by the statutory text. Instead of working with Congress to amend federal drug enforcement policy, he's instructed prosecutors to stop enforcing certain drug laws in certain states and mandatory minimum sentences for certain offenses. And most notably, the President has, without statutory authorization, waived, suspended, and amended several major provisions of his health care law. These unlawful modifications to Obamacare include delaying for 1 year Obamacare's employer mandate, instructing states that they are free to ignore the law's clear language regarding which existing health care plans may be grandfathered, and promulgating an IRS rule that allows for the distribution of billions of dollars in Obamacare subsidies that Congress never authorized. The House has acted to validate retroactively some of the President's illegal Obamacare modifications. However, rather than embrace these legislative fixes, the President's response has been to threaten to veto the House-passed measures. The President's far-reaching claims of executive power, if left unchecked, will vest the President with broad domestic policy authority that the Constitution does not grant him. Those in the President's political party have been largely silent in the face of this dangerous expansion of executive power. But what would they say if a president effectively repealed the environmental laws by refusing to sue polluters, or the labor laws by refusing to fine violators? What if a president wanted tax cuts that Congress would not enact? Could he instruct the IRS to decline to enforce the income tax laws? President George W. Bush proposed, unsuccessfully, a reduction in the capital gains rate. Should he have instead simply instructed the IRS not to tax capital gains at a rate greater than 10%? The point is not what you think of any of President Obama's individual policy decisions. The point is that the President may not, consistent with the command that he faithfully execute the laws, unilaterally amend, waive, or suspend the law. We must resist the President's deliberate pattern of circumventing the legislative branch in favor of administrative decision-making. We cannot allow the separation of powers enshrined in our Constitution to be abandoned in favor of an undue concentration of power in the executive branch. As James Madison warned centuries ago in Federalist Number 47, the accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. It's now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, and a good morning, top of the morning to the witnesses and to my colleagues on the House Judiciary Committee. The President's constitutional duty to faithfully execute the laws would be an important issue worthy of a hearing by this committee if there was any evidence that the President has indeed failed to fulfill his duty. But unfortunately, it appears that some here view policy disagreements as constitutional crises and proof of possible wrongdoing. The fact is that disagreements or even allegations that a program is not being carried out the way Congress intended should not raise constitutional concerns. If some of my friends want to disagree with the administration, it's of course certainly their right. But we should keep some perspective here and consider the following issues. To begin with, some of the administration's actions criticized by the majority are not really that much out of the ordinary. Allowing flexibility in the implementation of a new program, even where the statute mandates a specific deadline, is neither unusual nor a constitutional violation. It is rather the reality of administering sometimes complex programs. This has been especially true in the case of healthcare legislation. The Affordable Care Act is not the first time implementation of a new law has not gone according to schedule. President George W. Bush, for example, failed to meet some of the deadlines in Medicare Part D, even though it was legislation he strongly supported. And it's especially interesting that some members who strenuously oppose the Affordable Care Act and who work diligently to obstruct its implementation now complain that the President is unconstitutionally impeding the implementation of his signature legislative accomplishment. How interesting. Taking steps to deal with the realities of implementation of a complex program hardly constitutes a failure to take care that the laws are faithfully executed. It is rather part and parcel of doing just that. There have been administrations in the past that have obstructed the implementation of laws they opposed, but no one is seriously contending that President Obama opposes the Affordable Care Act, Obamacare, or that his administration's actions constitute intentional obstruction of the law. And when in the past there have been legitimate concerns about delays in the law's implementation, parties have turned to the Administrative Procedure Act. That act allows that courts determine whether a delay is unreasonable and order appropriate relief. Notably, no one has alleged that such action is necessary here. Instead, critics of President Obama and his signature legislation allege a constitutional crisis. But no court has ever found delay in implementation of a complex law to constitute a violation of the Take Care Clause. Now, some of my colleagues seem to think that the exercise of prosecutorial discretion, a traditional power of the executive, is a constitutional violation. The decision, for example, to defer deportation of individuals who were brought to the United States as children who haven't committed felonies or misdemeanors and do not pose a threat to public safety, so-called dreamers, is a classic exercise of such discretion. The administration cannot legalize these individuals' status without a basis in law, but the administration's decision to defer action against particular individuals is neither unusual nor unconstitutional. The Supreme Court has consistently held that the exercise of such discretion is a function of the President's powers under the Take Care Clause. For example, in Heckler versus Cheney, the court held that an agency's refusal to institute proceedings shares to some extent the characteristics of a decision of a prosecutor in the executive branch not to indict, a decision which has long been regarded as the special province of the executive branch, inasmuch as it is the executive who is charged by the Constitution to, quote, take care that laws be faithfully executed, end quote. Finally, I hope we can distinguish between failing to execute the laws and following the explicit dictates of the law. Some here contend that the President's decision not to defend the Defense of Marriage Act violated the Take Care Clause. In fact, the President made a judgment subsequently vindicated by the United States Supreme Court that the act was unconstitutional. But while the case was pending, he continued to comply with the law. The President's decision not to defend the law was not novel. Indeed, Congress itself recognized this possibility. Congress understood that sometimes the administration's duty to take care that the laws be faithfully executed might include recognizing that a particular statute is unconstitutional. The Constitution is, as we are told in Article 6 of the Constitution, the supreme law of the land. Presidents are required to follow it. So past administrations have exercised their discretion not to defend a law while that they have deemed unconstitutional. For example, the acting Solicitor General at the time, John Roberts, now the Chief Justice of the United States, refused to defend a law that he believed to be unconstitutional in the 1990 case of Metro Broadcasting versus the FCC. Chief Justice Roberts argued that a statute providing for minority preferences in broadcast licensing was unconstitutional. Despite Supreme Court precedent applying a more permissive standard of review, he argued that strict scrutiny applied. Senate legal counsel appeared as amicus curiae to defend the law and prevailed. Clearly, there were reasonable arguments that Chief Justice Roberts could have made in defense of the law, yet no one suggested that he violated the Constitution by arguing for the court to strike that law down. His view was not vindicated in that case, but may ultimately have resulted in a shift in the law, which makes it additionally clear that the administration's decision not to defend DOMA was neither unprecedented nor inappropriate. And so I join with all of the committee in welcoming our witnesses, look forward to their testimony, and I yield back the balance of my time, Mr. Chairman.
Thank you, Mr. Conyers. Without objection, all other members' opening statements will be made a part of the record. We welcome our panel of witnesses today, and if you would all please rise, we'll begin by swearing you in. Do you and each of you swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that all of the witnesses responded in the affirmative. Thank you. And I'll now begin by introducing our witnesses. Our first witness is Jonathan Turley, the Shapiro Professor of Public Interest Law at George Washington University Law School. Professor Turley is a nationally recognized legal scholar who has written extensively in areas ranging from constitutional law to legal theory to tort law. He has published over 36 academic articles and over 750 articles in newspapers, including the New York Times, USA Today, and the Wall Street Journal. Professor Turley has been recognized as the second most cited law professor in the country. Our second witness is Nicholas Rosencrantz, a professor of law at Georgetown University Law Center. Professor Rosencrantz has served and advised the federal government in a variety of capacities, including as a law clerk to Supreme Court Justice Anthony Kennedy and as an attorney advisor to the Justice Department's Office of Legal Counsel. He has published numerous scholarly articles, including The Subjects of the Constitution, which is the single most downloaded article about constitutional interpretation in the history of the Social Science Research Network. Our third witness is Simon Lazarus, a senior counsel with the Constitutional Accountability Center. He is a member of the Administrative Conference of the United States and during his career has served as the Public Policy Counsel for the National Senior Citizens Law Center, as a partner at Powell Goldstein, and as Associate Director of President Carter's White House Domestic Policy Staff. Mr. Lazarus has written articles that have appeared in law journals as well as publications such as The Atlantic, The Washington Post, and The New Republic. Our final witness is Michael Cannon, the Cato Institute's Director of Health Policy Studies. He has been recognized as an influential expert on the Affordable Care Act. Mr. Cannon has appeared on ABC, CBS, CNN, and Fox News and has written articles that have been featured in numerous newspapers, including the Wall Street Journal, USA Today, and the Los Angeles Times. He is also the co-editor of a book on replacing the Affordable Care Act and the co-author of a book on health care reform. I'd like to thank all of the witnesses for their appearance today. Each of your written statements will be entered into the record in its entirety. I ask that each witness summarize his or her testimony in 5 minutes or less. To help stay within the time frame, there is a timing light on your table. When the light switches from green to yellow, you will have 1 minute to conclude your testimony. When the light turns red, it signals that the witness's 5 minutes have expired, and we'll turn first to Professor Turley. Welcome.
Thank you, Mr. Chairman, Ranking Member Conyers, members of the Judiciary Committee. It's a great honor to be invited to speak with you today. about the meaning of the Take Care Clause. You have to forgive my voice. I'm getting over a cold, but I hope to make it through this without having a coughing fit. This is obviously a difficult area of constitutional interpretation. As the ranking member pointed out, this is not the first time that we have dealt with this question. It is also difficult for some of us who happen to agree with the President's policies, which I do. In fact, I voted for him previously. However, in a Madisonian system, it is often more important how you do something than what you do. And the reason this is such an important hearing is that the bedrock of our Constitution remains the separation of powers. It is often misunderstood as some type of conflict between the branches. It is really a protection of liberty. It allows for issues that divide us to be cycled through a system in which factional interests can be transformed. Even though all branches are equal in the Madisonian system, the Congress is the thumping heart of that system. It is where issues that are divisive are transformed into majoritarian decisions. It is the very reason that our system has survived so well. It brings stability to the system. Benjamin Franklin used to say, or liked to say, that God helps those that help themselves. In our system, in the Madisonian system, the Constitution helps those branches that help themselves. It is designed to give each branch the ability of self-protection, of self-defense, and a great deal rides on the use of that power. In my view, some of the questions we're going to talk about today are close questions. Things like internet gambling, drug enforcement. I think you can have credible arguments on the administration side, but some of them I believe are not close questions. I believe the President has exceeded his brief. The President is required to faithfully execute the laws. He's not required to enforce all laws equally or commit the same resources to them. But I believe the President has crossed the constitutional line in some of these areas, which I address in my testimony. What I want to start in my opening statement is to emphasize that this is not a turf fight between politicians. Rather, this goes to the very heart of what is the Madisonian system. If a president can unilaterally change the meaning of laws in substantial ways or refuse to enforce them, it takes offline that very thing that stabilizes our system. I believe that members will loathe the day that they allowed that to happen. This will not be our last president. There will be more presidents who will claim the same authority. When I teach constitutional law, I often ask my students, what is the limiting principle of your argument? When that question is presented to this White House, too often it's answered in the first person, that the president is the limiting principle, or at least a limiting person. We can't rely on that type of assurance in our system. So the greatest danger of non-enforcement orders is not what it introduces to a tripartite system, but what it takes away. What it does is it allows for these issues that divide us to be resolved unilaterally. We don't have a dialogue anymore if someone can step in and make the legislative process simply an option as opposed to a binding stage or requirement. It is here in Congress that factional interests coalesce and convert. This is the transformative branch. It's different from the other branches, and that's what makes this so dangerous. What Madison did is he created a type of Newtonian orbit of branches. In fact, he was very interested in Newton's physics when he wrote much of the early writings. There's a belief that these are three branches that exist in orbit. They're held together by their gravitational pull. It's a delicate balance, but it's one that protects individual liberty. Federalist 51 is one of the most cited sources for Madison's views. It is in that writing that he encouraged branches to be on guard for the encroachment of their powers. For decades, this Congress has allowed its core authority to drain away. I've written a lot about the rise of what is called the fourth branch, this expanding number of federal agencies that are acting increasingly independently, even defining their own jurisdiction. If that trend is to continue and the president's powers to continue to expand, Congress will be left like a Maginot Line on the constitutional landscape, a sad relic of what was once a tripartite system of equal branches. There are times, like this one, of bitter, intractable divisions, but the members of this body are tied by a covenant of faith, an article of faith. And it is found in Article 1 that says that all legislative powers herein granted shall be vested in the Congress of the United States. It is upon that covenant that we shouldn't divide by parties, and we should stand firmly for the separation of powers.
Mr. Rosencrantz, welcome.
Thank you, Mr. Chairman, Representative Conyers, members of the committee. I thank you for the opportunity. Mr. Chairman, Representative Conyers, I thank you for the opportunity to express my views about the President's constitutional duty to take care that the laws be faithfully executed. I quite agree with
You
Representative
better
Turner.
check your microphone and pull it closer to you.
Can you hear me now?
Yeah, pull it real close, though.
Okay.
That'll work very well.
Sorry. So to speak about the Take Care Clause, I want to associate myself with Professor Turley's opening statements. I quite agree with all of his remarks. I'd like to just draw the committee's attention to the text of the clause. It's always best to begin by parsing the actual words. So first, notice that this clause is not a grant of power, actually, but the imposition of a duty. The President shall take care. This is not optional. It is mandatory. Second, note that the duty is personal. The execution of the laws may be delegated to other officers, but the duty to take care that the laws be faithfully executed, that's personal. That is the President's duty alone. Third, notice that the President is not required to take care that the laws be completely executed. That would be impossible given finite resources. The President does have power to make enforcement choices. However, he must make them faithfully. Finally, it's important to remember the historical context of the clause. English kings had claimed the power to suspend laws unilaterally, but the framers expressly rejected that practice. Here, the executive would be obliged to take care that the laws be faithfully executed. So with these principles in mind, it's possible to view some recent controversies through this precise, proper constitutional lens. For this purpose, I'm going to focus on three examples. The President's unilateral decision to suspend certain provisions of the Affordable Care Act, the President's unilateral abridgment of the Immigration and Nationality Act, and on the IRS's targeting of the President's political adversaries. So first, the Obamacare suspension. On July 2nd, 2013, just before the long weekend, the Obama administration announced via blog post that the President would unilaterally suspend the employer mandate of Obamacare, notwithstanding the unambiguous command of the law. The statute is perfectly clear. It provides that these provisions become effective on January 1st, 2014. The blog post makes no mention of the statutory deadline. This raises the question of what it means to take care that the laws be faithfully executed. Certainly, the adverb faithfully gives the President broad discretion about how to best deploy his executive resources. And the scope of that discretion can be the subject of legitimate debate. But this is not a mere calibration of executive resources. This is wholesale suspension of law in the teeth of a clear statutory command to the contrary. Whatever it may mean to take care that the laws be faithfully executed, it simply cannot mean declining to execute a law at all. Now, the President's remarks on this issue were quite striking. A few months ago, he said he would actually prefer to simply call up the Speaker of the House to request a change in this law that would have achieved the desired delay. But the truth is, he wouldn't have needed to pick up the phone. The House actually had already passed the Authority for Mandate Delay Act, but the president, far from welcoming this legislative change, actually threatened to veto it. So this seems almost like a willful violation of the Take Care Clause. Now, the second example, the Immigration and Nationality Act suspension, which the chairman mentioned, I'll just mention briefly. What's striking about this is the president's decision to enforce the immigration laws as though the DREAM Act had been enacted, when in fact it has not. So in this case, it's almost a mirror of the other case. Rather than declining to comply with a duly enacted statute, the president is complying meticulously, but with a bill that never became a law. Congress has repeatedly considered a statute called the DREAM Act. The president favors this act. Congress repeatedly declined to pass it. So the president has simply announced that he would enforce the Immigration and Nationality Act as though though the DREAM Act had been enacted. To put the point another way, the president's duty is to take care that the laws be faithfully executed. Laws, capital L, not those bills which fail to become law, like the DREAM Act. Finally, I'll just briefly mention the IRS targeting. If the adverb faithfully means anything, I would say that it means non-discriminatorily. That is, the president cannot enforce the laws in a discriminatory manner. And the story of the IRS targeting is actually the application of the tax laws to the president's political enemies in a discriminatory way. This is perhaps the single most troubling type of enforcement discrimination. And so in a way, perhaps the most troubling violation of the president's obligation to take care that the laws be faithfully executed. Thank you.
Thank you. Mr. Lazarus, welcome.
Thank you very much, Mr. Chairman, and thank you, Mr. Ranking Member Conyers, and all the members of the committee who are here. I'm afraid I'm going to have to disagree with my colleagues on the panel who have spoken so far. Brandishing the Take Care Clause has become a favored talking point for opponents of an array of Obama administration policies and actions. All of these efforts, or at least the ones with which I'm familiar, are in reality all these efforts to import the Constitution into what are in reality political and policy attacks are really rhetorical make-weights. They mock the text and original meaning of the Take Care Clause. They flout long-established Supreme Court precedent, and they contradict the consistent practice of all modern presidencies, Republican and Democratic, to implement complex and consequential regulatory programs, as Congressman Conyers pointed out. These critics fault the Obama administration for many things, but essentially two kinds of things. One, making necessary adjustments in timing of implementation of laws, and particularly the Affordable Care Act. And secondly, in matching immigration enforcement priorities with available resources and practical humanitarian and other exigencies. But exercising presidential judgment for such reasons is precisely what the Constitution requires. It is precisely what the framers expected when they established a separate executive branch under the direction of a nationally elected president and charged him to take care that the laws be faithfully executed. So let's first take a quick look at one of the targets of these charges, and that is the phasing in of the ACA employer mandate, which has been called a blatant illegality and many other things, but in fact, it's a routine temporary course correction. What exactly did the administration do? On July 2nd, it announced the decision to postpone for 1 year the January 1, 2014 effective date for the ACA requirement that large employers provide their workers with health insurance or pay a tax. This and other subsequently announced delays related to the ACA do not constitute refusals to enforce the ACA at all. On the contrary, they are merely phasing in adjustments designed to ensure effective implementation of the overall statute in accord with Congress's purposes. The Treasury Department's announcement makes that clear, and the proposed regulations that it has followed through on September 5th make that clearer, as does the Treasury's statement that it intends to continue fine-tuning those regulations and working with the people affected by them until they become finally effective. And I should emphasize that just after the administration took this action, President George W. Bush's HHS Secretary Michael Leavitt concurred that, quote, the Obama administration's decision to delay the employer mandate was wise, unquote. That was based on his experience in phasing in the Medicare Part D prescription drug benefit. So I have to say that hyperventilating about how extraordinary and unprecedented and unconstitutional these delays are is just that. It's hyperventilation, and it's contrary to obvious historical fact. Nor is the one-year delay of the employer mandate an affront to the Constitution. The framers could have prescribed simply that the president execute the laws. So why did they add faithfully and take care? And I have to disagree respectfully with Professor Rosenkranz and Professor Turley about their explanation of the history and original meaning of the clause. Obviously, they were taking pains to clarify that the president's duty is to implement laws in good faith, hence the word faithfully, and to exercise reasonable care, hence the word take care, in doing so. The fact is that scholars on both the left and the right concur that this broadly worded phrasing means that the president is to exercise judgment and to handle his enforcement duties with fidelity to all laws, including, indeed, the Constitution. As a legal and a practical matter, the president's phase-in of the employer mandate and other ACA provisions is well within his job description. So is the DACA program, the Deferred Action on Childhood Arrivals. I'm not going to go into that now, but Congressman Conyers explained why that's true, and in my written statement, we do so also. I have to say one quick word about what I know that my a good friend and frequent debating partner, Michael Cannon, is going to focus on, and that is his theory, and he gets credit for a lot of credit for thinking it up and marketing it. His theory that Affordable Care Act premium assistance tax credits and subsidies must be available to all, his theory that they are only available to Americans who happen to live in states that have set up their own exchanges. I can't go into detail about this. Unfortunately, perhaps in the questioning I'll be able to do that. But his theory is that a few phrases in this enormous statute have to be construed in a way that would stiff millions of people who were the intended beneficiaries of the act. Am I over? I'm over. The fact is that that is not the correct construction of the act, and perhaps we'll be able to talk about that further.
Thank you, Mr. Lazarus. Mr. Cannon, welcome.
Thank you.
You want to put that microphone on and
Thank
hold
you,
it
Mr.
close.
Mr. Conyers and members of the committee. I want to start off by saying that the concerns that I'm going to be sharing with you today are not born of partisanship. It's no secret that I have worked for Republicans. I myself am not a Republican. I'm acutely aware of the last Republican president's failure to execute the laws faithfully. In 2008, though I supported neither major party presidential candidate, I actually preferred Barack Obama to his opponent, in part because he promised to curb such abuses by the executive. And I've praised President Obama for doing more than even many libertarians to celebrate the gains in equality and freedom our nation has secured for women, for African Americans, for gays, and for lesbians. Article 2, Section 3 of the Constitution, to which every president swears an oath, commands that the president shall take care that the laws be faithfully executed. Fealty to this duty is essential for maintaining our system of government and public order. The law is a reciprocal pact between the government and the governed. Public order requires government to remain faithful to the law as much as it requires a citizenry to do so, because if the actions of government officials lead citizens to conclude that those officials are no longer meaningfully bound by the law, then the citizens will rightly conclude that neither are they. Since he signed the Patient Protection and Affordable Care Act into law, President Obama has failed to execute that law faithfully. The President has unilaterally taken taxpayer dollars made available by the PPACA and diverted them from their congressionally authorized purposes toward purposes for which no Congress has ever appropriated funds. He has unilaterally and repeatedly rewritten the statute to dispense taxpayer dollars that no federal law authorizes him to spend and that the PPACA expressly forbids him to spend. He has unilaterally issued blanket waivers to requirements that the PPACA does not authorize him to waive. At the same time, he has declined to collect taxes that the PPACA orders him to collect. He has unilaterally rewritten the statute to impose billions of dollars in taxes that the PPACA expressly forbids him to impose, and to incur billions of dollars in debt that the statute expressly forbids him to incur. He has unilaterally rewritten the PPACA to allow health insurance products that the statute expressly forbids, and he has encouraged consumers, insurers, and state officials to violate a law that he himself enacted. And he has taken these steps for the purpose of forestalling democratic action by the people's elected representatives in Congress. President Obama's unfaithfulness to the PPACA is so wanton that it is no longer accurate to say that that statute is the law of the land. Today, with respect to health care at least, the law of the land is whatever one man says it is, or whatever this divided Congress will let him get away with saying. What this one man says may flatly contradict federal statute. It may suddenly confer benefits on favored groups or tax disfavored groups without representation. It may undermine the careful and costly planning done by millions of individuals and businesses. It may change from day to day. This method of lawmaking has more in common with monarchy than with democracy or a constitutional republic. This president's failure or any president's failure to honor his constitutional duty to execute the laws faithfully is not a partisan issue. The fact that presidents from both parties violate this duty is cause not for solace, it is cause for even greater alarm, because it guarantees that presidents from both parties will replicate and even surpass the abuses of their predecessors as payback for past injustices. The result is that democracy and freedom will suffer no matter who occupies the Oval Office. I thank you, and I look forward to your questions.
Thank you, Mr. Cannon. I'll begin the questioning under the 5-minute rule. Professor Rosenkranz, oftentimes the legislative process is about negotiation, about give and take between competing interests and compromise. How does the President's creating, amending, suspending, and ignoring acts of Congress at will affect the legislative process?
That's a great question, Mr. Chairman. The short-term effect is an aggrandizement of the President, but a predictable long-term effect is legislative gridlock. There's every reason to believe that Congress will not be able to reach these compromises if they know that these compromises can be unilaterally rewritten in the White House. Every reason to believe that Congress will grind to a halt under the threat that President Obama will rewrite its handiwork.
In fact, couldn't you argue that that is indeed happening right now, that as you try to work out differences between various perspectives on a piece of legislation, those who may be asked to give something that they think the President agrees with them on might say, well, why should I give on that because I can get that changed or done unilaterally by the executive branch, and therefore, or the party that wants to achieve that says, well, why should I agree to it because they're not going to enforce that anyway.
You could imagine such a negotiation about the effective date of Obamacare, but after the statute is passed, President Obama decides what the effective date is, quite regardless of what Congress wants. So gridlock is quite a predictable result.
Professor Turley, the Constitution's system of separated powers is not simply about stopping one branch of government from usurping another. It's about protecting the liberty of Americans from the dangers of concentrated government power. How does the President's unilateral modification of acts of Congress affect both the balance of power between the political branches and the liberty interests of the American people?
Thank you, Mr. Chairman. The danger is quite severe. The problem with what the President is doing is that he's not simply posing a danger to the constitutional system. He's becoming the very danger the Constitution was designed to avoid. that is the concentration of power in any single branch. This Newtonian orbit that the three branches exist in is a delicate one, but it is designed to prevent this type of concentration. There's two trends going on, which should be of equal concern to all members of Congress. One is we've had the radical expansion of presidential powers under both President Bush and President Obama. We have what many once called an imperial presidency model of largely unchecked authority. And with that trend, we also have the continued rise of this fourth branch. We have agencies that are now quite large that issue regulations. The Supreme Court said recently that agencies could actually define their own or interpret their own jurisdiction.
I'm going to cut you off there because I've got a couple more questions I want to ask and only 2 minutes left. But Mr. Cannon, you've argued that the President is going to spend billions of dollars Congress did not authorize to provide premium assistance tax credits and subsidies on federally run healthcare exchanges. Could you please quickly walk me through why the President's plan to provide premium assistance on federally run exchanges is indeed illegal?
Well, we call those premium assistance tax credits because that's what the statute calls them, but in effect they are government subsidies, they're government spending. And the statute is quite clear. It is consistent, it's unambiguous, it was intentional and purposeful. When it said that those premium assistance tax credits would be available to only to people who purchase health insurance through an exchange, quote, established by the state under Section 1311. That's not just one mention of that phrase. The phrase is mentioned several times explicitly and through cross-references. The statute is very tightly worded, and it makes clear that those tax credits are available only if a state establishes an exchange itself under Section 1311. If the federal government establishes a federal fallback exchange, those tax credits are not available because that exchange is established by the federal government under Section 1321, as the Obama administration has acknowledged in regulation.
Thank you. I agree. Professor Rosenkranz, some defenders of the President's unilateral actions have asserted that his actions were merely an exercise of prosecutorial discretion. Are these assertions correct, or is there a fundamental difference between prosecutorial discretion and many of the President's unilateral actions?
So there are many cases that are close cases. I agree with Professor Turley, but some of these cases are not close. So prosecutorial discretion is one thing, but wholesale suspension of law is quite something else, and that is what has happened under Obamacare. Likewise, in the immigration context, kind of case-by-case prosecutorial discretion is one thing, but a blanket policy that the Immigration Act will not apply to 1.8 million people, that's quite something different. This is a scale of decision-making that is not within the traditional conception of prosecutorial discretion.
In fact, the President has taken it a step further and has actually given legal documents to the people in that circumstance, well beyond simply deciding not to leave them there and not prosecute them, but actually enable their violation of the law by giving them documents to help them evade the problems that ensue from living in a country that they're not lawfully present. Is that
quite right?
Correct?
Let these leaders be mindful that our families are here to just...
Presently, we do not have order in the hearing room. Members of the audience must behave in an orderly fashion or else they'll be removed from the hearing room. Rule 11 of the House Rules provides that the chairman of the committee may punish breaches
Speaker,
of
could
order
we
and
get
decorum
security to help?
and exclusion from the hearing. The Capitol Police will remove the disruptive members from the audience immediately.
Or would the chairman yield? Are you allowing some to be able to sit down and therefore comply rather than removing them from the hearing room?
I have conferred with the ranking member, and since we afforded them that opportunity earlier in the hearing, now they're going to be required to leave.
Well, my passion is with those who are leaving. Thank you for being here, and I hope that we will come to an understanding of our hearts.
Out of order. My time has expired, and the chair now recognizes the ranking member, Mr. Conyers, for his questions.
Thank you. I am interested in the presentation of Professor Lazarus, who was explaining some of his differences with the witness to his left. And I would like to ask if he could pick up that line of discussion. We're pleased that you're here because there's been so much excitement or excited rhetoric about where the president and his administration are going. I've never heard this level of hypothesizing as to where this is all going to take us, and I think it's considerably over the top. I'm so glad you're here today, and I'd ask you to respond, please.
Thank you very much, Mr. Conyers. The theory of that the Affordable Care Act actually intended to cut off the very benefits that the law was passed to create to the very core constituency of needy people that was the target of the law that my friend Mr. Cannon came up with is something that no one on either side of the aisle had any idea about when the law was passed. He and some other clever colleagues came up with this theory at least 9 months, I think, after the law was passed. And the fact is, and they were very happy that they did so, they have gloated that their theory, if adopted by the courts, would drive a stake through the heart of Obamacare, that's their words, that it would sink the ACA and threaten its survival. In fact, however, the law's text does not sabotage the universally acknowledged purpose of ensuring access to health insurance for all the millions of Americans who cannot now afford it. To make their implausible case to the contrary, Mr. Cannon and his colleagues snatch a few isolated words out of context and ignore the rest of this huge statute. But if you look at the entire statute, you quickly have to conclude that the whole text, not just these isolated phrases, harmonize the purpose of the statute with its text and mean that all Americans who are eligible for the benefits to enable them to afford insurance will be able to have them whether or not they reside in federal exchange states or state exchange states. And I want to add just one quick thing, and that is, so Mr. Cannon and his friends soon realized that their reading of the text didn't make sense and hang together. So they came up with an even more head-scratching claim, and that is that the sponsors of the law, quote, intentionally and purposefully designed it to achieve this self-immolation. Mr. Cannon just referred to that argument. So what this means, it means that the ACA sponsors actually intended not only to stiff the very people that they wanted to benefit, it actually means that they intentionally handed over to Mr. Cannon's allies in state capitals the stake that he talks about and invited them, if they chose to do so, to drive it through the heart of the ACA. I mean, we have to imagine, really, in order for your theory to make sense, one has to imagine Senator Baucus, Senator Murray, Senator Reid, that well-known soft touch, Senator Schumer, getting together in a floor, in a room off the Senate floor and saying, I know what we're going to do. We're going to enable all the Republican governors and state legislators just to decide that the ACA won't work in their states. Unsurprisingly, there's not a single piece of evidence in the legislative record to support this notion. What is really going on, I'm afraid, is that having lost politically, having lost in the Supreme Court, the ACA opponents who are clinging to this theory are hoping that the courts will bail them out once again. That's an awfully big political lift. I don't think that the courts are going to do that.
Thank you so much. Mr. Chairman, I would ask unanimous consent to put in the record this report by the New Republic of November this year entitled Obamacare's Single Most Relentless Antagonist, who is our distinguished witness here today.
I think
reserving, can I just ask one quick question, Mr. Chairman? Is the New Republic doing reports or articles?
reports or articles. I can't tell you. You mean on the one that I'm introducing?
Yes, Mr. Ranking Member. I only ask because I'm fine to have newspapers and op-eds and so on put in the record. I just want to have them characterized not as a report, as though they have some substantive factual backing.
Well, I've never been asked this question before.
Well, only because I'm often called the president's antagonist, and I'm not sure that a report that left me out would be justified as factual.
Well, without objection, the New Republic article entitled "Obamacare's Single Most Relentless Antagonist," and I'm sure both the author of the theory with regard to the federal use of those funds and the gentleman from California would both be proud to have the article in the record, and therefore we will, without objection, make it a part of the record.
And I'm sorry to disappoint my friend, whose name isn't even mentioned in this article. Thank you, Mr. Chairman.
The chair recognizes the gentleman from Texas, Mr. Smith, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, in my judgment, the President has ignored laws, failed to enforce laws, undermined laws, and changed laws, all contrary to the Constitution. It seems to me that the President is trying to make laws by executive decree at news conferences. But in a 2012 interview, the President said that he could not, quote, wave away the laws that Congress put in place, end quote, and that, quote, the President doesn't have the authority to simply ignore Congress and say, we're not going to enforce the laws that you've passed, end quote. Yet it seems to me that is exactly what he has done. I'd like to address my first question to Professor Turley, Professor Rosenkranz, and Director Cannon. I think I know their answer. But the question is, do you think, in fact, the President has acted contrary to the Constitution? Professor Turley, you mentioned that you supported the President's policies and even voted for him, yet you say he has crossed the constitutional line, the legislative process is not an option, and what the President has done is dangerous. So I assume your answer is yes, the President has acted contrary to the Constitution. Is that right?
It is, and I would also just add, Congressman, that this was an issue that the framers considered, 150 years before they drafted this provision, which didn't change much in the committee. This was a fight with James I, and the framers were very familiar with it, and I think that's what gave life to this very clause.
Thank you. And Professor Rosenkranz, do you think the President has acted contrary to the Constitution?
Representative, I would say that some of these cases are close cases, but some are not. So the wholesale suspension of law, for example, is, I would say, the paradigm case of a Take Care Clause violation, yes.
Okay, thank you. And Director Cannon?
Yes.
That's quick and easy. Thank you. My next question is a little bit tougher, and that is, what can Congress or the American people do about it? How can we restrain the President from acting in a way contrary to the Constitution? And Professor Turley.
That is, I think, the most difficult question that we face. I've had the honor of representing members of both parties of Congress in going to the courts, and the courts are quite hostile towards members standing, for example, when they believe a violation of the Constitution has occurred. It is, in fact, members standing that would solve many of our problems. That is, if members could go to the courts and raise violations of the Constitution, that would be, it would make much of these difficulties go away. You'll note that the administration has made reference to the fact, and I think they have some support for this, that they doubt people would have standing to challenge many of these acts. So we have something that the framers would never have accepted, that you can have violations of the Constitution, yet literally no one can raise the issue successfully with the courts for review.
Okay, Professor Rosenkranz.
Well, I'm actually not sure I agree with Professor Turley on the standing question. It's quite true that some of these violations may not be amenable to judicial review. Ultimately, though, the check on this sort of constitutional violation is elections. So this is exactly the sort of hearing we ought to be having, exactly the sort of hearing that the electorate ought to be paying attention to for our next round of elections.
Okay, thank you. And Director Cannon.
I think there's little that Congress can do if it is divided over the president's abuse of his authority. But fortunately, and as far as judicial remedies go, it's very difficult to challenge an action of the president when he relaxes an obligation on a certain party. It's much easier to find a plaintiff who has standing to challenge an action that imposes new obligations that the legislature never approved. That is what has happened in the case of the president issuing premium assistance tax credits through federal exchanges, because those tax credits will trigger tax penalties on employers and individuals in those 34 states that have refused to establish an exchange. And a number of those employers and individuals, including 2 state attorneys general, 15 Indiana school districts, and a dozen or more private employers and private citizens have filed suit, four different lawsuits. In fact, one of them will have oral agreements this afternoon here in Washington, D.C. So there is judicial remedy for some of these abuses.
Okay, good. Thank you, Director Cannon. Thank you, Mr. Chairman. Yield back.
Chair now recognizes the gentleman from New York, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Mr. Lazarus, Professor Rosenkranz has written in a Wall Street Journal op-ed piece that Abraham Lincoln would not approve of the delay in the employer mandate and contrasts this decision with Lincoln's suspension of habeas corpus. Could you comment on the claim that Lincoln would disapprove? And what about the contrast with suspension of habeas corpus by Lincoln?
Yes, I read that article with some amusement, I have to say, Professor Rosenkranz. I think that President Lincoln would chuckle somewhat contemptuously at the notion that there is an equation between suspending the writ of habeas corpus, perhaps the most fundamental guarantee of freedom in our whole system, with a temporary delay in the implementation of a regulation that's of a provision that's part of a very complex new law, which is something that happens under all administrations. It has to happen sometimes for practical reasons. Why we are making a big fuss about this as a constitutional matter, well, it's not beyond me. I understand why it's being done. If it sounds like politics, that's what it is. But to make that kind of a comparison, Professor Rosenkranz, doesn't do justice, I think, to your position at Georgetown.
May I?
Thank you. No, I have too little time for too many questions. Let me start by saying that I generally, in many respects, agree with Professor Turley about the growth of the imperial presidency over the last half century or more. I'm particularly concerned about the abuse of the war powers by many presidents, the use of the state secrets doctrine to prevent enforcement of constitutional rights, the dragnet surveillance that we've seen under Bush and Obama beyond the contemplation of the Patriot Act, warrantless surveillance in the Bush administration, and things like that. I must say that everything we're talking about today is laughable, in my opinion, in the context of these problems. I'm particularly struck by the overwhelming hypocrisy of the claim that the president, in interpreting the law, in refusing to interpret the law in a way that would drive a stake through the law, is not enforcing the law. In demanding that he enforce the law on the dates in a way that the person making that demand says would destroy the law, is not taking care of the law to be faithfully executed. I would say it's the other way around, that it's the duty of the president to interpret the law within the boundaries that he has in a way that makes practical the implementation of the law to effectuate the will of Congress. And the fact that people who want to sabotage the law and want the law not to work and make no bones about it say, hey, he's not obeying this particular sentence in order to make the law work. Talk about hypocrisy. Let me ask a question. Having made my statement, I want to ask Mr. Lazarus the following question. There's Judge Kavanaugh in the District of Columbia Circuit recently, in a decision by Judge Kavanaugh, recently wrote the following: the executive's broad prosecutorial discretion and pardon powers illustrate a key point of the Constitution's separation of powers. One of the greatest unilateral powers the president possesses under the Constitution, at least in the domestic sphere, is the power to protect individual liberty by essentially under-enforcing federal statutes regulating private behavior. More precisely, the power either not to seek charges against violators of a federal law or to pardon violators of a federal law. Now, this would seem to support broad discretion in the executive branch to set enforcement and therefore non-enforcement priorities of drug, immigration, and other laws. Does it not? And how does that relate to the alleged violation of the Constitution by the President in setting immigration enforcement priorities as was outlined earlier?
Well, thank you very much, Congressman Nadler. And of course, what Judge Kavanaugh, who is one of the most respected and most conservative judges on the federal bench, what he said here is absolutely correct. And the principles that he's enunciating are precisely why a court, if faced with the issue, would undoubtedly uphold as perfectly compatible with the President's discretion in the immigration area in particular, the DACA program that my co-panelists here are claiming is a gross violation of his duty to see that the laws are faithfully executed. I'd like to, if I can, just quote one other authority, and that is the Supreme Court. In an important decision about a year and a half ago, a 5-3 majority, including Justice Kennedy, who wrote the opinion, and Chief Justice Roberts, opined that, quote, a principal feature of the removal system in the immigration area is the broad discretion exercised by immigration officials. Federal officials, he said, as an initial matter, must decide whether it makes sense to pursue removal at all. And they went on to say that discretion in the enforcement of immigration law embraces immediate human concerns. Unauthorized workers trying to support their families, for example, likely pose less danger than alien smugglers or aliens who commit a serious crime. Now, that very recent broad-based decision, like Judge Kavanaugh's remarks, is completely at odds with the critics' cramped interpretation of the President's immigration enforcement and his constitutional authority.
Well, I wanted to ask Mr. Rosencrantz to ask if he agreed with Judge Kavanaugh and the Supreme Court. If I'll ask unanimous consent for one additional minute, so Mr. Rosencrantz can answer that, Mr. Chairman.
Without objection, gentlemen will have additional 1 minute. Mr. Rosencrantz.
I'm glad you asked, because Judge Kavanaugh also said quite recently in 2013, quote, the President may not decline to follow a statutory mandate or prohibition simply because of policy objections. Of course, if Congress appropriates no money for a statutorily mandated program, the executive obviously cannot move forward. But absent a lack of funds or a claim of unconstitutionality that has not been rejected by final court order, the executive must abide by statutory mandates and prohibitions. I think Judge Kavanaugh is exactly right here.
Of course, that's not the question. The question was delay here. But thank you.
Chair recognizes the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman. Mr. Rosencrantz and Mr. Cannon, Mr. Lazarus had commented upon previous writings of yours, but you weren't afforded the opportunity to respond. Did you want to take a moment to do that? I'll go with you first, Mr. Rosencrantz.
Yeah, thank you so much. So there was a comment about an op-ed that I wrote in the Wall Street Journal comparing Lincoln's suspension of habeas with President Obama's suspension of Obamacare. Of course, I agree with Mr. Lazarus that these things are not the same. Habeas and Obamacare are not the same, but what is striking about the comparison is that President Lincoln welcomed the involvement of Congress, welcomed Congress to ratify what he had done, to pass a statute justifying what he had done. He was concerned that perhaps he had overstepped his constitutional authority. He welcomed Congress's ratification of his action. President Obama, by contrast, actually threatened to veto a statute that would have ratified his action. That, I think, is the startling contrast that I was trying to bring out in that op-ed.
Thank you, Mr. Cannon.
Well, Mr. Lazarus, and whenever this issue comes up of whether premium assistance tax credits are authorized in the 34 states with federal exchanges, supporters of the administration of the IRS's decision to offer them in those states with federal exchanges talk a lot about what Congress must have been thinking or could possibly have been thinking, or would they have done this. And there's a reason they do that. It's because the statute is clear and it contradicts what the Obama administration is trying to do. And unfortunately for the administration, the legislative history also is completely consistent with the clear language of the statute. They have offered, despite 2 years of people like me raising this issue that what the IRS is trying to do is illegal, they have yet to offer one shred of one statutory provision or one shred of evidence from the legislative history that supports their claim that this statute authorizes tax credits through exchanges established by the federal government under Section 1321, or that it was Congress's intent for this statute to authorize tax credits through those exchanges. So there's a lot more to be said about all of this. If I may, I'd like to respond to something that Mr. Nadler.
Let me cut you off at this point. Okay. I've only got a limited amount of time. Mr. Turley, let me ask you this. You had mentioned something along the lines of you were concerned that President Obama is becoming the very danger that the separation of powers was meant to prevent. Mr. Lazarus mentioned earlier that I don't know who exactly he's referring to, but some are hyperventilating about this whole topic. Would you want to comment on both of those things, either in relation to each other or not?
Sure. Mr. Lazarus may be responding to my labored breathing with the flu, but it's not my testimony. The reason I think that we have this disconnect in our view of this clause is that we obviously read the history differently. I view the Constitutional Convention is quite clear. The framers were students of history, particularly James Madison. 150 years before they took a pen and wrote out this clause, there was a fight with James I about what was called the royal prerogative. It's very similar to what President Obama is claiming, the right of the king to essentially stand above the law, to reform the law to the king's views. Now, I'm not saying that President Obama was a monarch, but that was the issue that gave the impetus to this clause, in my view. The language of the clause did not change very much. Later, people like Benjamin Civiletti dealt with this under a different term, the dispensing power of the president. And Civiletti wrote a very good paper about when the president could refuse to enforce laws. And he basically said that it could only be done where there is an intrusion upon executive power. And by the way, that's what was involved in the Myers case that we talked about, referred to earlier. Or if it was clearly unconstitutional. And that second issue, he established it had to be very, very clear so the president does not exercise dispensing authority. So this is how I would respond. We don't have to hyperventilate to look at a problem of this kind and say that this is not about who the president is today or what he's trying to achieve. What is lacking from the other side is any notion of what the world will look like in a tripartite system if the president can literally ignore any deadline in a major piece of legislation, exclude whole classes of people from enforcement. The question is, what is left in that Newtonian orbit that Madison described? And I would suggest what's left is a very dangerous and unstable system.
Thank you very much. My time has expired. Yield back.
Chair recognizes the gentleman from Virginia, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. Mr. Lazarus, first of all, on the ACA, it seems to me absurd that the federal exchanges that are there for all intents and purposes to serve as the state exchange or state marketplace, it would be absurd to interpret that they're there for all intents and purposes except for the purpose of the bill, which is the subsidies. Is that right?
It's obviously absurd, Congressman Scott, and therefore to say that the president is violating his duty to see that the law is faithfully enforced because he interprets the law in a way that is consistent with its purpose and consistent with the known objectives of the Congress that enacted it is also, it seems to me, quite absurd.
Thank you. The Congressional Research Service provided several examples in prior administrations where the IRS delayed enforcement despite a congressionally mandated effective date. Can you say a word about the president's power to delay implementations of provisions particularly when compliance is logistically impossible?
Yes, and I think actually, despite the sparks that are flying around this room about the President's actions with respect to the Affordable Care Act, these principles are really quite simple. Several people have noted that the President cannot refuse to enforce a law for policy reasons. That's obviously correct, certainly correct, and it's also obviously not what the President is doing. Does the President have policy objections to the Affordable Care Act? I don't think so. Phasing in the enforcement of major statutes like the Affordable Care Act or the Clean Air Act or other laws, certainly laws that the EPA administers, miss statutory deadlines very, very frequently because it's simply logistically impossible to prudently implement them in accord with those deadlines. This is just a tempest in a teapot.
Thank you.
And if I can say one further thing about your first question, Congressman Scott, we should understand what the consequences of Mr. Cannon's interpretation of the ACA would be, and why it would drive a stake through the heart of the ACA in every federal exchange state. It's not just that it would keep maybe 80% of the people who are expected to enroll for insurance on exchanges from being able to afford that insurance, 80%. So it would really wreck that part of the program. But actually, it would probably just cause the entire individual insurance market, even for people who could afford insurance, to implode, because it would so screw up the actuarial calculations. So it really would drive a stake through the heart of the law in those states, and to say that Congress intended to do that is I don't know. It's just pretty hard to stomach.
Thank you. In November 1999, 28 bipartisan members of the House wrote the Attorney General a letter and expressed concern that INS was pursuing removal in some cases, quote, when so many other more serious cases existed. How do you set priorities? If the President can't set priorities in enforcement, when there's obviously not enough money to enforce each and every provision to the letter of the law, how do you set priorities if he can't enforce each and every provision?
The answer is it's the essence of the executive responsibility to do just that. And I might note that I think that President Obama has increased the number of deportations, to the consternation of some of his own supporters, a very great deal, as everyone here I'm sure is well aware. And my understanding is he's increased it to 400,000 people a year, which is like nearly 4 times as many as the number was around 2000. The reason for that is that that's all the funds that Congress has appropriated for that.
My time is about to expire. I wanted to get in one other question. Can you talk about the obligation of the President to defend Defensive Marriage Act when he believes it to be unconstitutional?
Yes, I think I agree that the President should only very, very rarely and with extremely good reason decline to defend a law in court, and I've written about that. And I think it's hard to fault what the President did in the case of DOMA. He concluded with very good reason there was simply no argument that could justify DOMA. He notified Congress of this decision. He continued to enforce it. He invited Congress to intervene in litigation to present that point of view. And ultimately, the Supreme Court vindicated his judgment. So it seems to me it's very difficult to complain. Everyone on all sides of these debates and in both parties agrees that the Take Care Clause contemplates that the President may decline to enforce a law which he concludes in a responsible way is unconstitutional.
The gentleman's time has expired.
Mr. Chairman, I ask unanimous consent to introduce into the record the letter I referred to.
Without objection, so ordered. The gentleman from California, Mr. Issa, is recognized.
Thank you, Mr. Chairman. Mr. Lazarus, I hear you on the President deeply believing in his policy, his signature legislation, the Affordable Care Act. But he deeply believes, I'm sure, in every item that he wants appropriated from Congress. But 2 years later, it expires, right? And 2 years later, he can't just spend money unless he comes back to Congress for more money. Isn't that true? That's implicit in the Constitution?
You know, I apologize, but I don't really understand the question, Congressman Issa.
When the President's authority has run out, he must come back to the Congress for new authority. In the case of the Affordable Care Act, things which were not in the law have gone wrong. This act, this 2,400 pages that had to be passed and then read, has flaws in it, and these are fatal flaws if not corrected. Isn't that so? Including the absence of an answer to how do you subsidize if, in fact, a state chooses not to do it. Mr. Rosencrantz, if the law does not give the President authority and something goes wrong, I'm presuming that the framers always intended that you would come back to the Congress to resolve that need for additional authority. It's happened. It was earlier mentioned Abraham Lincoln came back to have his suspension of habeas, attempt to have it ratified, because he knew he didn't, even if he did it by executive order, he had limited jurisdiction. He wanted to have it codified. I think a good example would be MacArthur's promise in war. They came back with the Rescission Act in order to undo some of the promises that were made in war to the Filipino people and so on. Is there anything in the Affordable Care Act that is different than any other time that something that's not in the law occurs, that's outside the law, that you come to Congress and say, I need authority to do X? Please.
I quite agree, Congressman. It's really quite startling that this Congress, this House, offered to ratify exactly what the President wanted to do, actually passed a bill which would have delayed the employer mandate exactly as the President wanted, and far from welcoming this, the President actually threatened to veto it. To me, that's quite startling.
Well, I want to go through a couple things I think we can all agree on and get to something Mr. Turley said. Would you all agree, without further pontificating, that when Andy Jackson heard from the U.S. Supreme Court that he had no right to move Native Americans out of their homes to Oklahoma, and he then did it anyway, saying essentially to the Supreme Court, you have no army, therefore I'm doing it, that he was outside his constitutional authority? You'd all agree to that. Let the record show I had all...
Certainly would agree to that.
Okay, I had all shaking heads. When Richard Nixon tried to withhold his tapes, which were essentially evidence of his complicity in the Watergate and the cover-up, and the court ordered those tapes, even after he'd fired a number of people and so on, you'd all agree that the court's action was appropriate, that there was a crime, it went to the White House and ultimately led to Richard Nixon resigning. You'd all agree that it was appropriate, I assume, for the court to intervene in this constitutional dilemma of a president that didn't want to turn over evidence related to his crime. Would you all agree?
I would.
Good.
I did.
And would you all agree, maybe, maybe not, that when the President Bush asserted in the Harriet Miers case, and this was referred to earlier, that when Judge Bates essentially said Congress has a need to get people in front of it, whether that person speaks or not, ultimately, and this is Mr. Conyers' case, that in fact the court intervened and said, yes, I have a right to decide, and you must produce witnesses. You'd all agree that that was a good balance of power decision by Judge Bates. Is that correct? In George W.'s case? Okay. Then on what basis does President Obama say he's above the law when in Fast and Furious he asserted that the court had no right to even decide whether or not a lawfully delivered subpoena should in fact be complied with? And in this case, Judge Amy Berman Jackson has ruled that, yes, she has the right to decide it. The question for all of you is, if we cannot go to the courts as Congress with our standing after a contempt vote, if we cannot go and get the court to decide the differences between the two branches, then in fact, as some of my Democratic friends have asserted, the imperial presidency is complete. Isn't that the most essential item, that if in fact we don't have standing, if in fact the court doesn't have a right to decide, then the executive power is essentially unlimited? Mr. Turley, you've written on this.
May I answer?
I'd ask for that same 1 minute for full answering.
Without objection, the gentleman may grant 1 additional minute.
I certainly agree that that's part of the problem here, is that we've created a system by which presidents can assert powers that others view as unconstitutional. I think the president's asserting clearly unconstitutional power in this case. And then the Department of Justice proceeds to try to block any effort of judicial review. This administration has been very successful in that, largely on standing grounds. And so there's no ability to challenge these things, even if they're viewed as flagrantly in violation of the Constitution. I'll also add, with reference to your earlier point, one of the things that the courts say when those of us who represent members go to the court and say the president's acting unconstitutionally, we hear this mantra from the judges saying, well, you have the power of the purse. But in this case, is the power of the purse is being violated. We have hundreds of millions of dollars that are being essentially shifted in a way that Congress never approved. And so we have, in many ways, the perfect storm. Even the power of the purse that's often cited by the courts really doesn't mean much if the president can just shift funds unilaterally without any type of review.
Anyone else?
I guess the only thing I would say, and I don't claim to be an expert on standing, as I think some of my co-panelists.
I'm more interested in a standing of the court, which was the question. Does the federal court have the right and obligation to make those final decisions on essentially balance of power? And if not, aren't we doomed?
Well, I just say 2 quick things. I mean, first of all, the courts do not have authority. They have authority under the Constitution to hear cases and controversies, and the courts do not have constitutional authority to decide matters that don't that are not cases or controversies, and that's why we have standing rules. The second thing I just say, Congressman, and also
so refusal to comply with a subpoena would not be a problem. Therefore, Nixon should never have resigned because his tapes never would have been discovered. In your example,
I don't think that follows.
He didn't turn them over without being ordered to.
Yeah, he might have. Well,
Mr. Rosencrantz, final.
I guess I'd just say some of the standing questions may well be tricky, but again, the ultimate check on presidential lawlessness is elections and, in extreme cases, impeachment. But elections primarily should be the check.
So when the IRS prevents the word from getting out by conservative groups, they in fact thwart the election. Therefore, elections are no longer the final answer, are they?
Right. To the extent that the IRS targeting is an example of discriminatory enforcement, you're quite right. It's actually the most corrosive form of Take Care Clause violation because it does cast doubt on everything that follows, casts doubt on the elections that follow. So you're quite right.
Thank you, Mr. Chairman.
The gentleman from Georgia, Mr. Johnson, is recognized for 5 minutes.
Thank you, Mr. Chairman, for holding this very important and significant hearing today. I get my notes squared away. This hearing is pure political theater. It's a farce, plain and simple. It's a comedy, but the audience has seen it so many times now that it's no longer funny. In fact, this hearing is an egregious waste of this committee's time, especially when one considers all of the legislation that remains unaddressed by the House, like immigration reform. The Senate has passed comprehensive immigration reform, but the Speaker of the House continues to refuse to bring the issue to the House floor. Yesterday, as House members walked down the Capitol steps on their way home from an exhausting 1-hour workday, I watched as most members had their heads down. They wanted to avoid eye contact with the 50 or so young people standing at the foot of the steps in the cold wind. They had their hands clasped together, the young people, in prayer. Their prayer was on behalf of those families of immigrants that are being destroyed as a result of this nation's failure to pass comprehensive immigration reform. Their prayer was a simple one, that Speaker Boehner allow the House to vote on comprehensive immigration reform before the end of this session of Congress. The spectacle of those kids shivering in prayer in the cold last night could not be avoided by the members of Congress. So most kept their heads down, probably in shame, as they hastily escaped to the safety of their cars. I suggest that this committee hold a hearing on the question of why, despite immigration reform being supported by a majority of Americans, having been passed by the Senate, and the President having said that he will sign it if it ever gets to his desk, why is it that we can't bring that measure to the House floor for a vote? Mr. Chairman, this do-nothing House has only 7 days left, 7 legislative days left before it adjourns for its well-earned year-end holiday. The same Republican Party that has voted 46 times to repeal the Affordable Care Act is today, ironically, complaining that the President is not implementing the law quickly enough. But at its essence, this hearing, sadly, is simply a continuation of the majority's overwhelmingly obsessive and insatiable desire to kill the Affordable Care Act, which will enable 30 million Americans to have health care, 32 million Americans. 46 times they've tried and failed to kill it. The result of this hearing will not change the fact that Obamacare is the law of the land, and since today we are hearing testimony on the use of executive authority, let's not forget that the key authority for Congress to check the power of the executive is its Article I authority over appropriations. And by the way, this Congress has not yet passed a budget. Congress continues to shirk its constitutional duties under Article I. Funding the government through short-term resolutions is not leadership, and the American people deserve better. So after holding yet another hearing to obstruct this administration, perhaps this committee can also take up the question of Congress's duties under Article I in a hearing entitled "The Congress's Constitutional Duty to Appropriate Funds." Now, as far as the Affordable Care Act is concerned, the individual mandate is constitutional. It will reduce costs, prohibit discrimination against patients with pre-existing conditions, and extend coverage to the uninsured. It will extend coverage to 32 million Americans. The individual mandate is the key to this legislation being successful. It would ensure that millions of Americans will not have to worry about being denied health care because of a current medical condition or fear that their coverage will be capped if they get sick. To the members who have served longer than I on this committee, I invite you to look back to 2003 when a Republican-led Congress enacted the law creating the Medicare prescription drug program. Most Democrats voted against the bill in 2003. The program was also very unpopular with most Americans, but Democratic members worked hard when the program was implemented in 2006 and 2007 to make sure that their constituents received the full benefits of the program. It's unfortunate that the Republicans today are not doing the same thing. Mr. Lazarus, this is not the first administration to temporarily postpone the application of new legislation. How have prior Republican and Democratic administrations treated the implementation of statutes when statutory deadlines become unworkable?
Without objection, the gentleman will have 1 additional minute to allow Mr. Lazarus the opportunity to respond.
I'll try not to take the whole minute. The answer is that prior administrations have done just what this administration is doing because they have to. I quoted President Bush's Secretary of Health and Human Services, Michael Leavitt, in saying that the President's current decision to delay the employer mandate was wise, and he said that and then cited his own experience in phasing in Medicare Part D, the prescription drug benefit program. The Environmental Protection Agency, under all administrations, faces statutory deadlines that cannot be met. We all know that. The Bush administration was often chastised by environmental groups for missing statutory deadlines, and the environmental community charged in court, in fact, that the Bush administration was using delays as a cover for simply suspending the law as a de facto matter. I don't know what the basis for that was or was not. And of course, again, if a president refuses to enforce a law for policy reasons, that is a violation of his take care duties, but that's not what's going on here.
Thank you. I yield back.
The chair recognizes the gentleman from Iowa, Mr. King, for 5 minutes.
Thank you, Mr. Chairman. I thank the witnesses for your testimony. This has been among the most interesting that I've been seated here in my more than a decade on this committee. As I listen, I'm listening to Mr. Lazarus, and often your dialogue goes to the policy effect of this rather than being tied to the constitutional language or the statutory language, although you've referenced both. And I'm curious as to what you think the limited powers of the president might be, given you grant him such latitude to amend Obamacare, extend the statutory deadline because it conforms with the broader intent of the law, and your reference to the intent of Congress that they really intended to allow for the application of taxes and the distribution of refundable tax credits, even though Mr. Cannon testifies that that's not in the section that applies. So from a broader perspective, could you tell me how you think the president's powers are limited? And I maybe just ask, does he have the power to lay and collect taxes?
Well, first of all, I think that the president's powers are limited by what the statute provides. And I think I've said several times, I agree entirely that the president cannot simply refuse to apply or enforce a law for policy reasons.
But can he regulate commerce, for example?
The president is obligated to phase in a new law.
I'm sorry, Mr. Lazarus, I hear that, but I'm trying to get to the constitutional limitations that you think the president has. Let me just bypass the enumerated powers with the exception of, what would happen? And I'm concerned about Mr. Turley's statement that we get into a pretty dangerous area here if we don't have constitutional limitations. What if we just leap to the end of this thing? What if the president declared war? What if he assumed that authority? What is the recourse then? What would your counsel be to this Congress if we objected to such a thing? Or even if we objected to it on purely constitutional grounds and we thought it was a good policy decision and he vetoed our resolution to declare war? That should get us to the bottom of this discussion.
Well, the president doesn't have the authority under the Constitution to declare war. The Congress does. The Congress has not been enormously eager to exercise that authority in my lifetime. But that's a very complicated subject, and it's a subject of
thank you, Mr. Lazarus,
interplay between Congress and the executive branch. There is a War Powers Act. There are disputes about how.
Let me then pick it up from there. That I'm illustrating this point that if there's an incremental march down through as a president overreaching his constitutional authority, in my opinion, I think the opinion of many people on this committee in this room, he could assume among that any of the enumerated powers and the recourse that Congress would have, all the way down to the declaration of war, and the recourse that Congress would have would be pass a resolution of disapproval, or we could shut off the funding through the power of the purse, and the president's already assumed the power of the purse, and so the next recourse is go to the courts, and if we find out that the courts do not grant standing for members of Congress, then the next recourse is, I think as Mr. Rosencrantz said, the word that we don't like to say in this committee, and I'm not about to utter here in this particular hearing, the balance I want to come to is ask Mr. Cannon this question. The frustration of this balance of powers because of the disrespect for the various branches, the competing branches of government that come, and I'll argue that the Founding Fathers envisioned that each branch of government would jealously protect its constitutional power and authority, and that static balance that would be there would be the definition of a brighter line between the three articles of the Constitution. But what's your suggestion on what then finally resolves this? I know we said elections. If the elections are affected by decisions of the executive branch, what do the people do who are the final arbiters of this definition of the Constitution if they're even frustrated by the election?
Is this to me me or
I'm asking Mr. Cannon, please.
I think it was to me, and you're asking if there's no judicial remedy and there's no electoral remedy, what do the people do? To what particular sort of abuses are you?
Any one of the list of the enumerated powers, for example, ending with a declaration of war, because that's the starkest of all.
There is a procedure in the Constitution that it allows the people to amend the Constitution without going through Congress. That is another another method where the people can try to restrain the executive.
Let me suggest then, if that should happen, why would an executive with such disrespect for the Constitution today honor an amended Constitution from a constitutional convention?
That is an excellent question.
I think I'd like to turn to Mr. Turley and ask him if he's had a chance to reflect upon that earlier statement of the situation that we are in and where this goes. We need to look into this future, and I'd ask that unanimous consent for that additional minute to ask each of the witnesses to tell us what's America look like in the next 25 years if we have executive upon executive that builds upon this continual stretching or disregard of the constitutional restraints and the disrespect for Article 1. I start with Mr. Turley. And
you may answer the question as quickly as you can.
Okay. I really have great trepidation of where we are heading because we are creating a new system here, something that is not what was designed. We have this rising fourth branch in a system that's tripartite. The center of gravity is shifting, and that makes it unstable. And within that system, you have the rise of an Uber presidency. There could be no greater danger for individual liberty. And I really think that the framers would be horrified by that shift, because everything they dedicated themselves to was creating this orbital balance, and we've lost it.
As I've said before, I think the ultimate check is elections, but I don't think you should be hesitant to speak the word in this room. A check on executive lawlessness is impeachment, and if you find that the president is willfully and repeatedly violating the Constitution, if on your hypothetical he were to declare war, I would think that would be a clear case for impeachment.
Well, I guess this is the first time I've heard anyone complain about the possibility that this president is going to unilaterally declare war and be over-aggressive about that. I don't really think that's much of a description of his foreign policy. But Congress has lots of power if it chooses to use it. The power of the purse is an enormous power. I think that if I were you, I'd find ways to influence policy in using the Congress's powers, which you're not doing. I mean, for example, we're hearing complaints about the president's actions to not enforce deportation against certain classes of immigrants. Instead of complaining about that, this committee could hold a markup and report out a comprehensive immigration reform bill, send it to the floor.
Mr. Lazarus, you are, not you, but the questioner is 2.5 minutes over. So if you can dispense with giving us advice on what our legislative agenda should look like and answer the question, I'd be grateful to you.
Okay. Well, but that is an answer. I think that Congress has a lot of power and it can use it.
Okay. And I assume that the failure to exercise is also an exercise of power, the failure to act. Mr. Cannon, would you like to briefly answer?
Maybe Mr. Lazarus knows better than I do how many bombs the president has to drop without congressional authorization before that becomes war. I don't know the actual number. But I think what Mr. King was getting at is, there is one last thing to which the people can resort if the government does not respect the restraints that the Constitution places on the government. Abraham Lincoln talked about our right to alter our government or a revolutionary right to overthrow it. And that is certainly something that no one wants to contemplate. But as I mentioned in my written and my delivered testimony, if the people come to believe that the government is no longer constrained by the laws, then they will conclude that neither are they. That is why this is a very, very dangerous sort of thing for the president to do, to wantonly ignore the laws, to try to impose obligations on people that the legislature did not approve, et cetera.
An excellent conclusion. Thank you, Mr. Chairman. I yield back.
The chair would now recognize the gentleman from Pennsylvania, former United States Attorney, Ms. Marino.
Thank you, Chairman. Professor Lazarus, you made a statement about, at least I inferred, about this being political. I want to assure you that I left a lucrative law practice to come to Congress in 2011 because I continually see the eroding of the Constitution. I'm a constitutionalist. It's what protects us. So I'm not here for the pomp and circumstance, for the notoriety, or to promote my career. I'm here because I'm concerned about the future of my children in the Constitution. So I want to make that perfectly clear. Number two, you made a comment, and again, I inferred that the intent, there was no intent wasn't an issue or was an issue in part of the Affordable Care Act. And I don't want to get into the details of that, but I find that interesting that you made intent the issue when the Speaker of the House at that time, Nancy Pelosi, said we have to pass it before we know what's in it. Okay? So, you know, let's get real about this. Now we're finding what is in it or what is not in it, and I'm hearing consistently from my constituents, small businesses, how this is destroying them. Let me be the first to say that I think everyone needs health care. And those that cannot afford it, we that can afford it, have to help those individuals. I firmly and truly believe that. And so with that, I would like to read you something. I'm not a constitutional expert, but I loved constitutional law. I follow constitutional law ad nauseum. Just ask my wife. I'm always talking about constitutional law. But in Federalist Papers 51, it said, what is government itself but the greatest of all reflections on human nature? And it went back to refer to, but the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachment of the others. And the government was set up to specifically prevent that. And the problem is, I am seeing here, not only in this administration, but in the previous administration and several administrations, the executive branches taking for granted that they have exclusive power over issues that they don't. And I'm concerned about that. And what do we do to prevent that? But where does it stop? And here's my question. You know, we've seen the president and past presidents concerning the War Powers Act, which I think have violated the Constitution. But in this administration, stopped enforcement of detaining illegal immigrants, stopped enforcement of drug laws. I know that because I'm a prosecutor. I saw it. Stopped enforcement of mandatory sentencing, stopped parts of Obamacare, the Benghazi issue, the AG being held in contempt, the IRS issue. How many more things do you think have to occur? And I'm thinking like a prosecutor. One of those in and of itself is not enough evidence. Two of those in and of itself is not enough evidence. But the violations that I see here that I just listed, and there are many more, I think is enough evidence to start asking questions. Where do you see the line drawn in what I've recited here as enough evidence to start asking questions about presidents exceeding their power?
Well, first of all, Congressman, I can't address all of the
and I don't
many
expect
things
you
that you've raised, but many of those things, I mean, let's be honest about it, are honest disagreements about policy or about how to interpret the law. And
so your interpretation of the law is, you're saying you don't agree with the way perhaps I'm interpreting the law, so you say I'm wrong.
No, just to finish the sentence, raising the specter of some kind of grotesque presidential assertion of unwarranted authority here, it's just not based on fact. Mr. Cannon, for example, strongly believes that his interpretation of the law, which would sink Obamacare in his in his view, is correct, or I guess he does. The president disagrees with that. The president has very good reason to disagree with that. So to say that he's not taking care that the law be faithfully
Okay, let me reclaim my time here. But when laws are enacted, they should be followed to the letter, and it's not being done here. And I've heard you raise the issue of, well, prior administrations have done it. To me, that's no excuse not to pursue this from a congressional standpoint, because whether it's Obamacare, whether it's War Powers Act, whether it's going into Iraq, these are all issues that I'm deeply concerned about. So you've criticized and you've made some, I think, remarks concerning that I don't think you take some of this seriously of what your colleagues have to say up there. So give me an answer as to what you think we need to do to get to curtail the executive power the way I think it's been abused over the years.
You may answer the question quickly.
Well, I think you can pass legislation to overturn an executive action you disapprove of. You can withhold funds for it.
Well, let me ask you, show something right there that you're not reciting either. 94% of Obamacare is mandatory spending. And the Democrats passed that unanimously without any votes from the Republicans. So it's mandatory spending. Nothing can be done about that at this point. It's the law. And I yield back my time. Thank you.
Thank the gentleman from Pennsylvania. Chair will now recognize the gentleman from New York, my friend Mr. Jeffries.
Thank the distinguished chair as well as the distinguished ranking member for his leadership and the panelists for their participation this morning. If I could just start with Professor Rosenkranz, and I want to explore this issue of prosecutorial executive branch discretion, particularly in the context of the enforcement of our nation's immigration laws. But if I could just start with some foundational questions. The Department of Justice, for example, is an executive branch agency, correct?
Yes.
And federal prosecutors within the Department of Justice are exercising executive branch action in the context of their participation in the criminal justice system, correct?
Or exercising executive authority, yes.
Executive authority. Mm-hmm. Now, when prosecutors make a decision to, after initially charging someone with a serious offense and then agree to a plea bargain to a lesser included offense, short of what they may have concluded the evidence provides that particular defendant was guilty of, is that an appropriate exercise of prosecutorial discretion within the four corners of the Constitution?
Well, I guess it depends on the circumstances of your hypothetical. It would not be appropriate if it were, for example, motivated by race or something, but on the facts you've described, if the prosecutor thought he didn't have the resources to prosecute a particular crime, or perhaps wasn't sure that he had the evidence for a particular element of the crime, then yes, that's an appropriate exercise of discretion.
And the executive branch, and in the prosecutorial context, for instance, the Department of Justice, or in the immigration context within Homeland Security, they have an ability to prioritize the nature of the offenses that they enforce. Is that correct, as an appropriate exercise of their constitutional authority?
The executive branch has authority to husband its resources in the most efficient way that it sees fit. So the president doesn't have the money or resources to completely execute every law, and so he does have to, by necessity, make decisions about enforcement priorities, yes.
Now, so you've concluded, I believe, that the presidential exercise of authority in the DACA context with respect to deferred action, certain class of individuals, do you believe that that's an unconstitutional exercise of his authority?
Sorry, in the immigration context?
In the immigration context.
Yes, I do.
And you believe that's the case because of the fact that you contend it was a wide-ranging exercise that was not made on a case-by-case basis? So what is the foundation of your belief that it's unconstitutional?
I think there are two basic reasons. One is that it goes dramatically further than the hypotheticals we were discussing before. This is not a prosecutor deciding on a case. This is a president deciding on 1.8 million cases. And the second striking thing about it is the president deciding on exactly the set of cases that Congress considered exempting and decided not to exempt. That's what's particularly shocking about it.
So now you're familiar with, reclaiming my time, you're familiar with the criteria that has been set forth for the determinations that are made, I believe, on a case-by-case basis as it relates to who qualifies for this deferred action, are you not?
Yes.
Okay, and so for instance, one of the criteria, you must have entered the United States before their 16th birthday and be younger than 31 as of June 15, 2012. That's one particular criteria. Another is cannot have convictions for any felony offense, significant misdemeanor, or have committed any 3 misdemeanor offenses. Those are pretty specific enumerated categories. But another category which helps to determine whether discretion is appropriate is you cannot pose a threat to public safety or national security. Isn't that a pretty broad category within which discretion can be exercised on a case-by-case basis as to whether, in fact, you pose a threat to public safety or national security, that is not a specifically constrained factor that people either automatically fall within or automatically fall without?
Well, I think it's quite a dramatic shift in the status quo. So 1.8 million people will presumptively be allowed to stay. I can't imagine but a tiny fraction of them will be found to fall within that exception.
Okay, and I would just note that of these individuals, more than 450,000 have been granted deferred action, but in excess of 100,000 have been denied access or who have not received that grant of discretion, and I yield back.
Thank the gentleman from New York. The chair will now recognize himself for 5 minutes of questions. It strikes me that the law can require action or forbid action. The law can forbid the possession of child pornography. The law can, in some instances, require you to file an income tax return. Mr. Lazarus, is the chief executive constitutionally capable of ignoring both categories of law?
Well, as I said several times, Congressman Gowdy, the President cannot refuse to apply or enforce a law for policy reasons.
Well, let's analyze that for a second. Congress decided in its collective wisdom that if you possess X amount of a controlled substance, you are going to get X amount of time in prison. You may like mandatory minimums, you may not like them. This administration summarily dispensed with that law. So my question to you, again, is can the chief executive fail to enforce categories of law that are both permissive and mandatory?
Well, it is well established that the executive branch has prosecutorial discretion to decline enforcement.
And what are the limits of that prosecutorial discretion?
You know, very frankly, I'm not an expert on that.
Well, let me ask you this. Can the president, let's assume that a statute required you to show 2 pieces of identification to purchase a firearm. Can the chief executive knock that down to 1?
I guess I'd have to know a little bit more, but I would...
It's a very simple fact pattern. You have to show 2 forms of ID to possess or purchase a firearm, Can the chief executive, under his pardon authority or his prosecutorial discretion authority, knock that down to just 1 form of identification?
Well, I'm not aware of limits on the president's pardon authority.
So you would say he could?
Under the pardon authority, the president can pardon just about anyone, not that he should. No.
Even before the act is committed?
That's the reason for...
Can he do it before the act is committed? That's my question.
I'm sorry?
Can he do it before the act is committed?
Again, that's above my pay grade. I don't really know that.
If the president can fail to enforce immigration laws, can the president likewise fail to enforce election laws?
Whether the president can pardon someone before a prosecution is initiated? or before an act?
Well, I think I know the answer to that question. Now, my question was before the act was committed. He certainly can before the prosecution. My question is this: if you can dispense with immigration laws, or marijuana laws, or mandatory minimums, can you also dispense with election laws?
Again, I think we've gone over this ground many times.
Well, just humor me. Let's do it one more time. Can the president suspend election laws?
No.
Why not? If he can suspend mandatory minimum and immigration laws, why not election laws?
Because we live in a government of laws, and the president is bound to obey them and apply them.
Well, he's not applying the ACA, and he's not applying immigration laws, and he's not applying marijuana laws, and he's not applying mandatory minimums. What's the difference with election laws?
We have a disagreement as to whether, in fact, he is applying those laws. My view is that he is applying those laws.
Did Eric Holder instruct his prosecutors to no longer follow the mandatory minimums with respect to charging decisions?
Now, this is an area where I really don't know nearly as much as you do, Congressman.
I'd find that shocking that anybody would not know more than I do on any topic. Who would you like? You want me to ask Professor Turley?
That my impression is that he's not exactly doing what you've just said.
Well, tell me how I'm wrong, because Eric Holder sent out a memo that we are no longer going to put in the indictment the drug amounts. Do you agree with me that Congress can pass mandatory minimums?
Constitutionally, yes.
Do you agree that Congress can pass statutory maximums?
Pardon me?
Can Congress also pass statutory maximums? In other words, you can't get more than 30 years for a crime.
Of course.
Can a president exceed a statutory maximum?
Can he extinguish, did you say?
No, can he exceed it?
Can he exceed it? Well, how would he do that? I mean, keep someone in prison beyond his prison term?
Well, if you can put them in prison for less time than Congress says is the law, can you also do it for more time than Congress says is the law?
It's really, it's not, this is kind of fruitless because it's an area that I really don't know.
Professor Turley, what are the limits of prosecutorial discretion? And if the president can suspend immigration laws, marijuana laws, why not election laws?
Well, I think that some of these areas I can't imagine can be justified through prosecutorial discretion. It's not prosecutorial discretion to go into a law and say an entire category of people will no longer be subject to the law. That's a legislative decision. Prosecutorial discretion is a case-by-case decision that is made by the Department of Justice. When the Department of Justice starts to say, we're going to extend that to whole sections of laws, then they are engaging in a legislative act, not an act of prosecutorial discretion. Wherever the line is drawn, it's got to be drawn somewhere from here. It can't include categorical rejections of the application of the law to millions of people.
Well, my time is up, but I would just tell you that I always thought prosecutorial discretion was an individual prosecutor determining whether she or he has enough facts to substantially result in a conviction on a case-by-case basis. If a president is ignoring entire categories of the law, whether it be immigration, marijuana, mandatory minimum, the ACA, what is the remedy for the legislative branch?
Well, first of all, the first part of that question is, as you may know, I do criminal defense work. I would never go to a prosecutor and say, I want your prosecutorial discretion to say that the entire class of which my client belongs cannot be subject to this law, because prosecutors would look at me and say, are you insane? I am not Congress. So I wouldn't even raise the question. Now, in terms of where we go from here, I'm not too sure, because the great concern I have for this body is that it's not only being circumvented, but it is also being denied the ability to enforce its inherent powers. Many of these questions are not close in my view. The president is outside the line. But it has to go in front of a court, and that court has to grant review. And that's where we have the most serious constitutional crisis I view in my lifetime. And that is, this body is becoming less and less relevant.
With that, we would recognize the gentlelady from Texas, Ms. Jackson Lee.
Let me thank the majority and the minority, Mr. Conyers, for holding this hearing. Let me thank the witnesses. Whenever witnesses come before our body, It is, of course, valuable, and we trust your judgment, although we may disagree with you vigorously. Let me say that the wasteland that Mr. Lazarus spoke of, and Mr. Lazarus, please let me cite you and indicate that I will be using this across the land, the vast lands of this nation, which is a rhetorical make-waste that this hearing equates, but also to suggest that the reason why this body that Professor Turley has suggested may be on the verge of some basis of irrelevancy, which I take issue with, is because under the present House leadership, we've passed no legislation for the president to be able to implement in the first place. We have not passed immigration reform. We have not dealt with the question of mandatory minimums. We've not dealt with a budget process. We've not dealt with sequester. If we would simply do our job, the relevance to the American people would exceed our expectation. I just came from the Fast for Families. Just a few hours ago, we had in this room dreamers. As far as I'm concerned, the duty of the president is to be the ultimate giver of relief within the context of the Constitution and the necessary relief of the people who are begging for relief. If you read the lines that we are so intellectually gifted to interpret, along with precedents, it says that he shall take care that the laws be faithfully executed and shall commission all of the officers of the United States. Well, I could be a believer, and therefore my faith says that the president is taking, within the context of the laws, the ability to implement to help the most vulnerable. And what we're doing here is a rhetorical wasteland of ignoring the pain of our nation. Let me give you an example. First of all, my good friend from South Carolina knows full well, as a federal prosecutor, that each day prosecutors are making distinctive decisions about who to prosecute and how, within the context of the law. And to answer the question for you, Mr. Lazarus, the issue is that in the election laws, you follow the law, but you have the right in a prosecutorial posture to determine whether you are prosecuting or not. That is what happened with mandatory minimums. That is what's happening with the issue of drugs. That is what the Attorney General is speaking of. He is not throwing laws to the wasteland. We are in this hearing, for it has no sense to it. And then it is interesting that we have not understood the question of the Secretary of Homeland Security. She issued a memo to her staff. She has an inherent authority to deal with policy. Each of the deferred adjudications or the deferments for dreamers is individually assessed. What is this constitutional gobbledygook talking about? They don't understand the difference between policy and the ability to do that? And so I have had dreamers come to my office. I could not wave a magic wand. They had to go through the process. The memo indicates that it went to CBP, ICE, Immigration Enforcement, and others. And so I'm taken aback that this issue does not come with humanitarianism, and that if there should be a hearing, it should be a hearing of the failure of this Congress to act on its constitutional responsibilities. Let me ask you on the Affordable Care Act, which is now just another way, if I might say so, of having the 50th and the 52nd and the 53rd challenge on the Affordable Care Act. Mr. Lazarus, to go back to a comment about these exchanges, another wasteland, that if your state does not have an exchange, just on practical English, it means that you in the state cannot comply, meaning you, the citizen, are left in a wasteland of noncompliance. What do you get on? And so we have established the national exchanges. Would we have preferred to have state exchanges and to have a list of state insurers? Yes. Would we prefer for Republicans not to encourage young people not to do what is best for them by getting covered? Yes. But my question is, if the directive is to run such exchanges, that means the same characteristic, federal exchange, including the tax credit that allows poor people to have insurance. Obviously, these are allowed. I'm sort of coming in the middle of my question, Mr. Lazarus. This is for you. In essence, in states that have refused exchanges, the federal government stands in the shoes of the states. Doesn't that further illustrate why you, not Mr. Cannon, are correct based on the pure text of the law, and that the president is carefully, faithfully implementing the law? Would you go over that for us again so that it can be in the record?
Well, that interpretation is what I support, what the President and the administration supports, and what I think will certainly prevail in court, and that is that what the law provides is that if a state declines to set up an exchange, then the federal government shall establish such exchange. It says such exchange in the law. And as you just stated, in common sense terms, the federal government then will stand in the shoes of the state in operating that exchange, and the exchange will be exactly the same, have all the same powers, authorities, and responsibilities that an exchange that's being managed by a state government would have. Any other interpretation, the one that my friend Mr. Cannon here is promoting so vigorously, makes no sense and would actually cause the whole exchange part of the ACA to fail in every one of these states. So it makes no sense whatsoever, I think.
May I just have an additional 30 seconds? He didn't answer. Does this not exceed, and I ask unanimous?
Yes, I'm sorry.
Does this not exceed the authority of the president?
We're already 2 minutes over, so if
You're
you
very
could
kind, Mr.
give us a
Chairman.
very pithy response.
Thank you, Mr.
Great.
Chairman. Mr. Lazarus, if you could.
I think the president is not violating his take care responsibilities by acting on the interpretation.
And do you associate with my interpretation of statements I made previously?
Mr. Chairman.
May I ask for a submission into the record? I'm finished.
You can submit all your questions from the record.
No. May I just submit a document of an
Without objection.
op-ed dated August 15, 2007 by myself on signing statements. Ask unanimous consent.
Without objection. Before I recognize the gentleman.
I thank the chairman
from,
and I thank the witnesses. I yield back.
Before I recognize the gentleman from Idaho, for those of our panelists who may not be able to avail themselves of the history of this committee from 2008 to 2010, the other side controlled this committee, and not one single solitary piece of immigration reform was produced. Now, let's be fair. I've got colleagues like the gentleman from Illinois who are equally desirous of immigration reform no matter who the president is. But let's don't rewrite history. From 2008 to 2010, the Democrats controlled this committee and nothing with respect to immigration reform. So don't talk to me now about what a huge priority it is. I recognize the gentleman
yield?
from Idaho.
Will the gentleman yield?
Mr. Chairman, thank you for the time. Panelists, thank you for being here. Mr. Lazarus, I've been listening to you for 2.5 hours now, and I have not heard a single time where you have told me where in the law the federal exchanges are given the authority to grant these subsidies. You talk about policy, you talk about what you think the president wants, you talk about what you think the Democrats want. Tell me in the statute, just one time, where it says that the federal exchanges are supposed to give this subsidy.
Yes, I didn't go into detail, and I don't think that my friend Mr. Cannon did either.
I think he did. He mentioned the numerous times where it gives it solely to the state exchanges.
Let me answer the question. First of all, I asked that the committee include written testimony that I gave to a subcommittee of Congressman Issa's oversight committee that goes into detail about what...
just name one. I just want one section of the law. I don't have that much time. Name one section of the law.
And secondly, I also have...
You don't know. Mr.
No, I didn't say I don't know.
Well, can you name one section of the law?
I wanted to say that I had...
One section of the law, Mr. Lazarus, where it says
I would cite two sections in particular.
Thank you. That's all I'm asking.
The first section is one that Congresswoman Lee referred to, and that is where the law says that in the event that a state does not set up its own exchange, then the Secretary of Health and Human Services shall establish such exchange. And our interpretation, the administration's interpretation, is that the word such exchange should be interpreted to mean that the exchanges will operate on the same terms and have the same authority. Michael does not agree with that, but
Okay.
that's the interpretation. Secondly, and I think this is really quite important, when the statute defines exchange with a capital E, it puts a capital E in there, it says exchange shall be an exchange established by the state under the relevant section. And then
I reclaim my time. I just asked you a simple question. Mr. Turley, Mr. Turley and Mr. Cannon, I think both of you, coming from different political points of views, had some of the same concerns that I had about the prior administration, about the Bush administration. In fact, I read some of your writings, Mr. Turley, before I was a member of Congress, and
bless you.
and I was very concerned about the imperial presidency. I was very concerned about having a Republican with Republicans in Congress who were not willing to be a check and a balance on a Republican president. And in fact, like Mr. Cannon stated in his testimony, I think it was you, I can't remember which one of you it was, who stated that maybe the one thing that you liked about Obama, you seem to agree with his policies, you seem to kind of like the fact that he was going to be a check on what previous presidents had done. So I'm actually really disappointed that we are here at this hearing today, and I'm surprised that my friends on the other side don't think that this is an important hearing, because they seem to bitch and whine for 8 years about what the Bush administration did, and all of a sudden they don't seem to have one single concern about what this president is doing with his authority. What do you have to say about that, Mr. Turley?
Well, I believe that this institution is facing a critical crossroads in terms of its continued relevance in this process. What this body cannot become is a debating society where it can issue rules and laws that are either complied with or not complied with by the president. I think that's where we are. And where Mr. Lazarus and I disagree, Mr. Lazarus keeps on saying, look, a president cannot ignore an express statement on policy grounds. I'm not too sure what is involved here. If you look at the individual mandate, the policy issue there was that a great number of people were upset. They felt that there was a bait and switch. That's not the same thing that we see with like the environmental statutes that Mr. Lazarus points out. That's a political issue, a policy issue, where the president said, I don't want this to happen now. And a lot of people are upset with it. That would seem to me, if that's not a policy question, I don't know what is. And by Mr. Lazarus's own definition, that would seem to be outside the authority of the president. But in terms of the institutional issue that you're raising, look around you. Is this truly the body that existed when it was formed? Does it have the same gravitational pull and authority that was given to it by its framers? You're the keepers of this authority. You took an oath to uphold it. And the framers assumed that you would have the institutional wherewithal and, frankly, ambition to defend the turf that is the legislative branch.
Mr. Cannon, it seems to me that Mr. Lazarus is arguing that the president can do anything that we refuse to act on. And I think that goes beyond what the constitutional powers that were given to the president by our founding fathers. In fact, if you follow his logic, it seems to me that if he next decides that he wants to make sure that nobody who came here illegally, who came here just to work in agriculture, for example, can be deported because there would be some humanitarian concerns about deporting these people, that he has the express authority to actually do that. I'm actually a proponent of immigration reform. I want immigration reform to be done, and I think the actions of the president have made it less likely that this body is going to act because we're not sure what he's going to enforce and what he's not going to enforce. What are your comments on that?
Well, I think that there's no bright line, as far as I know, to be drawn between enforcement discretion and legislating. I think that the president's actions with regard to the Patient Protection and Affordable Care Act, wherever you draw that line, he's on the wrong side of it. But I think that one way the best way to curtail the abuse of prosecutorial discretion is to have fewer crimes. We have a lot of crimes on our in our immigration laws that I just don't think should be there. I think our drug war creates a lot of criminals that, there are a lot of crimes on our books as a result of the drug war that should not be there. And that is why prosecutors across this country are stretched so thin, why prisons are overcrowded, and when you have a situation like that where you've got a surplus of crimes and not enough resources to prosecute all of them, then you get a lot, you put a lot more power in the hands of individual prosecutors as well as the executive branch generally to decide how these laws are going to be enforced and not enforced. I think on a macro level, that's how you try to attack this problem.
Thank you. I yield back for the time.
The gentleman yields. Chair will now recognize the gentleman from Illinois, my friend, Mr. Gutierrez.
Thank you very much, Mr. Chairman. Well, once again, we're not legislating in this committee. We could be using this time to find common ground and even have a strenuous and substantive debate on important public policy matters, but instead, I think what we're doing is offering empty assurances and shaping political messages for next fall. Rather than worrying about whether the president we know, and you quote, distrust or end quote, is enforcing our laws the way you would like them to, we could be making meaningful progress towards crafting and passing laws for the betterment of the American people. I hope this goes, the president isn't a member of this committee. He doesn't sit on this committee. He doesn't have a vote in the House of Representatives. We should craft legislation and get it done. And then we should make sure that that legislation is enforced. Now, I know that some people say, well, he's not enforcing the legislation. Let me just suggest to everybody, when he got sworn in as President of the United States, secure communities was nothing in this country. There are hundreds and hundreds of agreements with county, state, and local facilities. How do you think the apparatus was created to deport 2 million people in the last 5 years? By accident? That apparatus did not exist under George Bush. It was created under his administration and implemented by this president. And that's something that I'm happy about. 287G agreements that have been made with one locality after another. We're going to sit here and say that Congresswoman Sinema, our colleague, who hired one of the Dreamers after she applied for DACA and successfully got her work permit and is now her district director, her mom is under a current order of deportation. She quit her job today as a congressional aide to go and fight for her mom. And we're saying that he's not enforcing the law? I assure you that if you are fighting this administration, as I and many others are fighting this administration each and every day, you will find this president is indeed enforcing the law. Unfortunately, he should not be limiting his prosecutorial discretion. He should be expanding his prosecutorial discretion. Now, on the substantive issue of DACA, the fact is we passed the DREAM Act in the House of Representatives in the fall of 2010. 216 to 208. But then we went to the Senate, Mr. Turley, and over there they said you need 60 votes now to get something done. We always talk about the framers. I don't remember any framer saying you need more than one vote, the majority in the Senate. But now you need 60, so they only got 55. So clearly the established will of the majority of the senators and the House of Representatives was to do what? To protect the Dreamers. That's what the president did. He took the express will of the House and in the Senate, if not for this new rule that they invented, that they've had, I think, now for 35 years, that you need the supermajority of 60 votes. If we needed that here, even my colleagues on the Republican side would have a difficult time getting legislation passed. So all I'm trying to say is, when we move the ball forward, the president looked at it, and I just want to say that I don't know about the other, but it seems like Bo Cooper, former INS General Counsel, Paul Virtue, former INS General Counsel, these are general counsels of the INS. Each of them established that the President of the United States does have prosecutorial discretion when he gets to decide who to prosecute and who not to. And that's what he did. He set children aside and said, I'm no longer going to prosecute them because they do not present an imminent threat. And guess what, Mr. Chairman? A year and a half later, 500,000 of them are walking around. And I assure you, because I know the way this place works, if you could find one and bring him up here that shows how he's caused some danger or some harm, that person would have already have come. But the fact is that they're not. They're working in congressional office. 3 of them are working in my congressional office, filling out more. Look, they're American citizens and everything but a piece of paper. And all I want to do, and I want to establish, because the chairman is absolutely correct. I'm going to say this from my point. When we were in charge in 2007 and 2008, we were worried about losing our majority because your side was beating the crap out of us. I'm sorry, maybe that word shouldn't be used here. But that's what you were doing. So if a Democrat voted for immigration reform, your side would boom, 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 and knock them out, right? And then we were in the majority in 2009, 2010, and we did nothing. I agree with you, we did nothing. But let's not repeat history. Let's not say you didn't do anything, so we're not going to do anything. No, let's do something. I want to end with this because here's what I'd like to do. I want to step outside of my Democratic Party because I know there are men and women on your side of the aisle that want to step outside of their Republican Party and join an American party on the issue of immigration. Because I know there's common ground that we can reach. And then the president won't have to be taking these actions. Because more and more what you're going to find is people are going to say, Congressman Sinema's staffer, we shouldn't deport her mom. Mr. President, stop the deportation of that mom. So all we're going to do is, look, they're here. There are 11 million of them. Let's figure out a way how we legalize their status. And let's figure out if you want triggers, let's put the triggers in. But in the end, we're going to have to come back here. And when they become American citizens, they're all going to become American citizens. We should get over that. Because you know what's going to happen, Mr. Chairman? If we pass legislation and they all don't go to citizenship, the next day somebody's going to show up and say that Congressman Gutierrez didn't do a good enough job. Because that's the way this plays. That's the positive thing. Somebody comes and says we didn't do a good enough job. Thank you. You've been so kind and so generous. I know one thing. Eventually, we're going to have a hearing here. We're going to call you all back, and you're going to let us know how we're going to get this done. I pray that that happens. It's the right thing for America. Thank you very much.
Thank the gentleman from Illinois. The chair will now recognize the gentleman from Arizona, Mr. Frank.
Well, thank you, Mr. Chairman. Mr. Chairman, the subject of today's meeting is pretty profound, related to the rule of law, and there are so many examples that some of us point to, and it's hard to name them all, so I'm just going to point to a few that this administration seems to have stepped outside the boundaries of, quote, the rule of law. Taxing political contributions, again, not in the law. Political speech disclosures for federal contractors. The deep-water drilling ban. Mr. Holder's attempt to reform criminal justice by selectively enforcing our laws. Mr. Obama's unilaterally ignoring immigration laws in many cases. Recess appointments, unconstitutional recess appointments. Fast and Furious, were unconstitutional efforts there to walk guns. Unconstitutional wiretaps by of the AP. The IRS scandal, one of the more egregious ones, as the gentleman mentioned, that it subverts the entire political process. And, of course, Obamacare, which I'll touch on in a moment. But all of these are examples where this president, in the words of my friends on the left, has exercised prosecutorial discretion. That's the word. Presidential pardon powers. But I think they're more along the lines of Professor Turley said these could be considered royal prerogatives, which is, if my history is right, that's what we had that little unpleasantness with Great Britain about. So the subject here is of profound significance. And I would suggest, Mr. Chairman, that not only in the application of the law has this administration held themselves unconstrained by the Constitution or even the truth in many cases, but even in the process of getting the law. On Obamacare, this was passed in a unique situation where I see in Mr. Cannon's testimony especially, it's probably the perfect citation. I see in your testimony that you write, President Obama's quote, President Obama's unfaithfulness to the PPACA is so wanton, it is no longer accurate to say the Patient Protection and Affordable Care Act is, quote, the law of the land. And, it's kind of ironic because some of my colleagues, about 53 of us, have signed on to the House resolution stating that we believe that Obamacare has yet to be the law of the land because it violated the origination clause of the U.S. Constitution when it was passed. And we don't talk about that a great deal, but it is significant because the origination clause, which was vital to the Constitution ever coming into existence in the first place, it was the critical negotiation that took place to allow the Constitution to exist requires that all bills for raising revenue originate in the House. And incidentally, Mr. Cannon, your colleague Ilya Shapiro at Cato has written an excellent piece at laying out this argument. I'm going to ask that this be placed in the record here in a moment, and also would like to ask you to address it if you have a perspective of it. But the bottom line that is at issue here is that if the U.S. Senate can take a totally unrelated piece of legislation and strike everything but the number and take legislation that they call the Senate Health Care Bill and place it in its entirety, which raises taxes to an enormous degree, if they can take any bill in the House and do that, then I would suggest to you, especially after the Supreme Court has labeled Obamacare a tax, they've officially called it a tax. And if indeed it can be done this way, then I would suggest to you that the origination clause is a dead letter. There is no more purpose for it being in the Constitution. And it's something that I hope that we'll look at a little more carefully. So if it's all right, Mr. Cannon, I'm going to address my question to you. Do you have anything that would help illuminate this in ways that the rest of us can understand?
Well, this is a provision of the Constitution that hasn't really been used or employed by the Supreme Court to knock down any revenue measures that were alleged to have originated in the Senate instead of in the House as required by the Constitution. I think that what happened with the PPACA is a more extreme example of the abuse of a more extreme violation of the origination clause than what we have seen in the past. As you say, a bill came up with a totally unrelated revenue measure came over in the House, from the House. The Senate stripped out everything within that bill, kept only the bill number, H.R. 3590, I believe, and inserted into that the Patient Protection and Affordable Care Act, which had all sorts of revenue measures, including the individual mandate, which we didn't know then was a tax, but now we know it is a tax until the administration changes its mind again, which it continues to do. There's nothing in the bill number that's a revenue measure. That's not, all the revenue measures had been stripped out of that bill. So if the origination clause means anything, then it means that that revenue measure that the Senate passed and then the House passed and that we now call the Patient Protection and Affordable Care Act originated in the Senate, and the Senate did not have the power to originate a bill, a revenue measure like that. So, but the difficulty is, will the courts enforce that part of the Constitution? There is a difficult line to be drawn between when are you amending a revenue measure that came from the House and when are you originating a new bill? I think that reasonable people can disagree about where that line will be drawn. I don't think that reasonable people can disagree about whether the Senate's gutting of H.R. 3590 and inserting into that a totally new revenue measure is on. I don't think anyone can disagree that that is on the wrong side of that line. It remains to be seen whether the courts will uphold that part of the Constitution. If they do, then probably they would have to strike down the entire PPACA. Fortunately, there is a lawsuit that's making its way through federal courts. It's been filed by the Pacific Legal Foundation that challenges the individual mandate as under the origination clause.
Mr. Chairman, thank you. I guess when if this administration does not succeed in stacking the D.C. Circuit, we should find out whether the origination clause still means anything at all with the case that the gentleman mentions.
I thank the gentleman from Arizona. The chair will now recognize the gentleman from North Carolina, the former U.S. Attorney, Mr. Holding.
Thank you, Mr. Chairman. Professor Turley, throughout your testimony, you've alluded several times that there are instances that you believe that the President has stepped over the line. And we've talked about a number of them, but I just ask for you to recap and maybe give us our top 5 instances where you think that he has overstepped the line and breached the Constitution.
Well, thank you very much, Congressman. First of all, I do think that there's a number of provisions in the ACA where he did overstep the line. The The decision on individual mandates strike me as a rather obvious policy determination from the president that he did not want to see it enforced, given the amount of public opposition that occurred and accusations of a bait and switch. Those are all political issues. This was not some Clean Air Act regulation that was stuck in the mire of regulatory disagreements as to a command and control statute. I also believe that the mandate, the employer mandate, which was also extended, constitutes a significant change in legislation. I also believe that the immigration issue is well across the line. I actually agree with the president on the decision that was made, but that doesn't matter because it was not made in a way that is allowed under our Constitution. One of the things that I would point your attention to, Congressman Holding, is that if you look at each of these questions, a couple of things jump out at you. One is they happen to occur in areas of tremendous political division, if not deadlock. That is precisely the type of issue that the framers wanted to go through the legislative process, because our process, unlike other systems that would explode into the streets of Paris and other cities, we have a type of constitutional implosion. We direct those pressures to the center of Congress. And from that, we take disparate factional interests and turn them into a majoritarian compromise.
If I could get you to keep going down the list of instances where you think that he has overstepped.
The other two that really come out to me is really the issue of the $454 million in the prevention fund issue for the federal health care insurance exchange, and also the $700 billion for the state exchanges, and then finally essentially the subsidies for congressional employees, which is less significant than those other ones. What bothers me about those last examples is that it goes directly to the power of the purse. And we have seen over and over again courts saying, don't worry, you have the power of the purse. And this administration is now directly challenging that and saying, we can take money that was dedicated for one purpose and give it to an unspecified, unallowed, or a disallowed purpose. That challenges the very rock foundation of the Congress.
Mr. Rosencrantz, do you want to add any to this list of, I've got 4?
Well, I agree with all the items on that list. A recent D.C. Circuit opinion spoke of the Nuclear Regulatory Commission refusing to make a decision about Yucca Mountains. That's quite a striking example. That's the example where the Judge Kavanaugh quote came from. And the other example that I really want to keep returning to is the IRS targeted enforcement. So to my mind, taking care that the laws be faithfully executed, the core of that requirement is non-discriminatory enforcement.
Mr. Lazarus, do you want to add any to this? Perhaps not. Mr. Cannon, would you like to add any to this?
I'd like to ask, isn't the Nuclear Regulatory Commission...
I'm going to reclaim my time, Mr. Lazarus. Before I get to you, Mr. Cannon, I want to use my last minute with Mr. Rosencrantz. Mr. Rosencrantz, you said that in extreme instances, impeachment would be appropriate to address one of these transgressions. We use the example of declaring war without congressional authorization. Say on a scale of 1 to 10, that being a 10 as necessitating impeachment proceedings. We've reeled off 6 instances where the president has exceeded his constitutional authority. I'd add a 7th in there on the what he's doing with our drug laws and the mandatory minimums and the insistence that our prosecutors not charge all the relevant facts. Out of any of these 7, which ones rise to the being the most egregious, and would any of them trigger what you would think, meaning impeachment, to be appropriate?
Well, I wouldn't want to opine on quite what the impeachment line ought to be, but I think this body should think about a pattern, if they see a pattern, and particularly if they see willful conduct. That should be that's really the most egregious thing a president can do, is willfully violate the Take Care Clause or display a pattern of of disregard for a constitutional prohibition. So that's what I think the committee should keep their eye on.
Mr. Chairman, I yield back.
Thank the gentleman from North Carolina. The chair will now recognize the gentleman from Georgia, Mr. Collins.
Thank you, Mr. Chairman. I've sat here and I've listened, and I've listened in the back, I've listened to both sides. The thing that just disturbs me more about this hearing, probably, Congressman King said it was one of the most interesting hearings that we've done and one of the relevant hearings. I'm not going to disagree with that, but I think for me it actually brings out one of the most disturbing hearings that we're having to have. And I think it's a progression issue here. And I'm not going to be Republican or Democrat. It's happened more in the last 15 to 20 years. I think this is a progression of executives that both Republican and Democrat have used, really in some ways push that boundary, stretch that boundary, and I think in the case of this, of the president now, has outright stepped over those boundaries. And we can have legal discussions up here all the time. The problem is from where I come from up in Northeast Georgia is people just, they don't get it. They look at a government, they look at an executive, they look at what's going on right now, and they just basically say, this is not the way it's supposed to work. This is not what you can go back to Schoolhouse Rock, you can go to a civics class, you can do whatever, and you can be graduated law professors, but at the same point, if you can't communicate it to the people who have to live under the situation, then there's mass problems, and I believe there's a right to have a mass problem right now. We've talked about the power of the purse. I've talked all session and ever since I got up here about I believe truly that this institution has got to matter again. It's Article 1. We've talked about Article 3 a lot, we've talked about Article 2 a lot, but it's Article 1. Congress has to matter again, and that means that we have to take seriously our role of budgeting, we have to take seriously our role of legislating, but also holding accountable when we are being bypassed. And that's a concern. And we've talked about using the power of the purse. I think that's been an issue that's been well trodden today. We've talked about elections, and I think that's an issue that has been discussed. But the other issue for me that is bothersome, and you try to explain, is what can you do? I'm often asked this. You got to go up there and you just impeach him. Or you go up there and you just impeach the president. Or you go up there and you just cut funds off. You shut everything down. And it just becomes a blur. And now we have Ms. Lazarus, and I respect your right to a differing opinion than mine on most things here, to say that I believe he has stepped over and you believe he hasn't. That's where we differ. And Mr. Turley, we'll agree on some things and probably agree on others. But you made a statement that said, agree or not, it was not in the bounds of the Constitution. And I think that's interesting for us to talk about for just a moment, because it comes back to what do we do? Besides getting our, quote, act together, if you would, as Congress, what can we do? Because standing is an issue that we're having to. So I want to ask you just this question. Where do we go to begin that process of reclaiming our Article 1, our constitutional role, so that it is a three-legged stool and not right now a 1.5?
Well, it's an excellent question, and despite my deepest concerns, I remain optimistic. I'm a Cubs and Bears fan, so I lived most of my life with unrequited desires. But it is as serious as you suggest, and there's a good reason why people can't understand what's going on, because we are acting outside the system. We've essentially taken the Madisonian system offline, and we are in this ad hoc improvisational world of constitutional law that is very, very dangerous. Where I disagree with my friend, Mr. Rosencrantz, is I'm always leery about people who say the solution is elections. The framers didn't intend for elections to be the solutions to constitutional problems. They created a system of checks and balances to allow the system to correct itself, because there are plenty of abuses. You could have majoritarian terror that would be just promulgated and continued through elections. Also, impeachment is not a good device for regulation. It's a very difficult thing. I testified at the Clinton impeachment hearings. It's a very difficult standard, and it's certainly not there as a substitute. I think that the hearing that this body should seriously consider is to have a hearing on member standing. I've been writing about this for years. I've represented members. If we had members standing, if members could go to court and raise unconstitutional acts, much of these problems would go away, because we'd be guaranteed review. Much of what we've seen from the White House, in my view, is based on the assumption, not necessarily a bad one, that nobody will be able to call them to account.
I believe you're right in that, and I think that's what, you said you were an optimist. I am too, if you've watched some of our sports teams lately in Atlanta. But I'm an optimistic realist, and I don't get on the plane to come to Washington, D.C. I still look at this Capitol, and I still believe it matters. I still believe that we're a shining light for the world. But I'm going to spend all of my time as best I can to bring us back to a balanced, checks and balance system in which Congress, Article I authority, is respected and honored, and we also have the system that most people in this country grew up understanding. And I think that's what this hearing ultimately is about, is the respect of the people who sent us here, and we've got to continue that. Mr. Chairman, I yield back.
Thank the gentleman from Georgia. The chair will now recognize the gentleman from Florida, Mr. DeSantis.
Thank you, Mr. Chairman. Mr. Lazarus, if Congress passes a statute that applies to whatever parameters you want, can the President enlarge the parameters of the statutory text and apply it to areas outside that the statute contemplated?
No.
Okay, because it's interesting because
I mean, let me just qualify that. This is an abstract question. It really depends on how the statute's
I understand.
worded. I mean,
and I'll give you a chance to respond because you cite bureaucrats within the administration to justify some of the president's conduct, but you actually don't cite any quotes from the president himself justifying his conduct. And I think it was interesting with this most recent, quote, legislative fix for grandfather plans. Here's what the president said. Already people who predate the ACA can keep those plans if they haven't changed. That was already in the law. That's what's called a grandfather clause that was included in the law. Today we are going to extend that principle both to people whose plans have changed since the law took effect and to people who bought plans since the law took effect. In other words, Obamacare has a grandfather clause. Anything after the enactment of Obamacare is illegal unless it meets the statutory requirements. So what the president is saying is he's extending a grandfather clause to cover plans beyond what the statute contemplates. So you think that that's appropriate?
I think you're making a good point. I think that it is appropriate if it is temporary.
And oh, by the way, let me just say, Congress, we passed in the House a bill that would have grandfathered in the plans, and I think that we should do that.
But what I meant to say was, I think it is appropriate as a temporary measure if it is necessary to effectively.
It's directly
phase the law
contrary
in,
to the
period.
statute. The whole point of Obamacare was that you needed to force people into these exchanges. What about this idea? If a political environment is tough, would that be a reason to delay a law or grant a waiver to a law if you cite the political environment as your justification?
I think that would be.
Congress isn't doing what I want. I may suffer political damage, so I'm going to do it anyways.
No, clearly that would not be appropriate.
Well, because I think in your testimony, and you did make some good points, I'll give you that, you didn't cite the president's stated justification for delaying the employer mandate. He was asked about it at a press conference. He said, in a normal political environment, I would pick up the phone, call the speaker, say, hey, this is a tweak that doesn't go to the essence of the law, and we would delay it for a year. But there's not a normal political environment when it comes to quote-unquote Obamacare is what he said. Now, to me, I think that that's totally outlandish of an explanation. It's even more outlandish because Congress, by the time he made that statement, had already passed a bill to delay the employer mandate precisely for the reason that the president suggests. Let me ask you one more question because Professor Turley, I really appreciate your written testimony, and you cite a lot of examples of the Founding Fathers. And Mr. Lazarus, you've made the point that, hey, the Take Care Clause doesn't mean what the rest of these guys say. Original understanding, founders understood it. But you didn't cite any actual Founding Fathers. So can you cite for me a Federalist paper? Hamilton wrote a number on executive power. Can you cite a Constitutional Convention debate, a ratifying convention debate, early practice in the Republic that would substantiate your assertion that that is consistent with the original understanding?
Yes. What I
Jefferson?
There's very.
Madison?
No, there's very little discussion.
Hamilton?
There's very little discussion, but what there is.
Well, right, so then you're
making
an assertion that's not justified by the historical fact. And I understand the theory that you're positing, but I think it's tough. You got to back it up. And I think Professor Turley backed up what he was trying to say. And so I'm asking you, who would you point to?
Can I finish?
Well, I want you to answer the question.
The answer to the question is that during the Constitutional Convention, this is what I said in my testimony, and this is what the basis of the interpretation is, and I think it's widely accepted. Originally, what became the take care clause didn't have faithfully and didn't have take care in it. It just said that the president shall carry into execution the laws. As the debate went forward, that got changed, and faithfully and take care were added. And
I understand that.
And what I said is that, and there really isn't, and what I said, what that clearly shows, and I think that what scholars on all sides have accepted, that shows that the president is to faithfully, in good faith.
Let me reclaim my time, because you have made that
and
point,
secondly,
and that wasn't my question. My question is about show me something I can go where Hamilton's saying this or not. You're talking about
this is
drafting.
even more powerful. It doesn't
and I think
matter.
Mr. Turley's point about the language is more correct. But let me just say one other thing.
This is the actual legislative record, and it is more.
So the text matters there, but it doesn't matter with the ACA because you're saying the purpose is different from what the text actually says. But I do think, though, the idea of when you're talking about Mr. Cannon's argument about, oh, nobody in Congress, they didn't intend for this subsidy to do. The idea that we know what Congress intended on a 2,600-page bill that many members did not read, much less understand. There were members here swearing you could keep your plan, you could keep your doctor, and now we have members of Congress running around saying, oh my gosh, I didn't know you wouldn't be able to keep your plan, your doctor. So the idea you're going to rely on that over the text of the actual statute, to me, I don't think, I'm a textualist, I would do that anyways, but with this health care law, I think of any law, surely you cannot point to what Congress intended into these intricate provisions because many of them did not read or understand it.
But it's Mr. Cannon. It's Mr. Cannon who is claiming that it was the intention. It was intentional and purposeful of Congress to construe the law in the cramped way in which he does.
I thank the gentleman from Florida. The chair will now recognize the gentleman from Texas, Mr. Gomert.
Thank you, Mr. Chairman, and I thank all of our witnesses. It's good to see some of you back. I don't remember seeing all of you, so otherwise it would be all of you. But if you would suppose with me that you are in a town hall back in a congressional district, and you had an elementary school student stand up and ask this question. I would like to know how each of you would answer this child's question. What right does the House of Representatives have to pick and choose what part of government gets funding? What's your response? Start with Professor Turley.
I'm sorry, the last part of the question.
What right does the House of Representatives have to pick and choose what part of government gets funded?
Well, I think the answer is clear, that in this sort of orbital hole that these three branches are placed by the framers, the key power given to Congress and the House of Representatives was the power of the purse to control the funds. What is alarming about this situation is that even that power is being challenged and being marginalized.
All right, Professor Rosenkranz.
Article 1, Section 8 gives you the power to decide what provisions, what you want to fund and what you don't want to fund.
And Professor Cannon, Lazarus.
Professor Rosenkranz took the words right out of my mouth.
Article 1, Section 8, is that okay?
Article 1, Section 8, along with the Senate.
Okay, and Mr. Chairman, I would ask that we provide a copy of the answer to this question to Senate Leader Reid, since he asked that question. Now, with regard to Libya, the President said he didn't need to come to Congress in order to get our authority to start bombing in Libya. And that was a concern to some of us. He said, he'd been asked by the Organization of Islamic Conference, all 50 or 57 states, whatever they got, 50, 57, and also by some of the NATO allies that use Libyan oil. So he didn't need Congress approval because he had those requests. He was initially prepared to help the Syrian rebels, in which al-Qaeda had become, not initially, but they had become the most profound part. And he was ready to start bombing the Syrian leader that Hillary Clinton had called a reformer. Initially, he planned to do that without Congress's consent. He didn't think he needed Congress's consent, but obviously once there was a lot of political pushback, he threw it to Congress and let them decide. But I'm curious from each of you, what gives the president the authority to order bombing, even if he promises to limit the numbers of people that he will kill? What gives him authority to go start bombing a country? Obviously, we'd consider it an act of war if any country started dropping bombs over us. But what gives him that authority? I'm curious from each of you.
Well, first of all, I think it's a great question, because I was a little confused when Mr. Lazarus says no one's accused President Obama of being inclined to engage in war without a declaration. I was in court with members of this committee saying exactly that in the Libyan war conflict. And what disturbed us is that the White House came back and said the reason we don't need a declaration of war is because the president alone defines what a war is, and he's simply saying this isn't a war. And when we talk about the dangers, this is a danger of a different kind. And it not only is a danger of separation of powers, obviously, and a direct violation of the express language of the Constitution, but this administration, through these acts and through the large number of drone attacks, is returning the world to a state of nature. We are taking down critical international legal principles that have governed this world, that have respected territorial limitations. I just spoke to the NATO parliamentarians, and I told them, you will loathe the day that you endorse the U.S. position, that they can take unilateral action when somebody vaporizes someone in the middle of London.
Well, my time is about to run out, so let me morph that into this question to each of you, get your answer. You know, the president ordered Anwar al-Awlaki killed by a drone strike in Yemen, an American citizen, without any due process, as we've come to know it. I asked the question in this room at another hearing, you know, how far does that order extend? I mean, if al-Awlaki came back to Capitol Hill and led prayers as he had before of congressional staffers, was that order still good? I wanted to know in case the drone strike was still on. What authority do you think the president has to order American citizens killed in other countries in which we're not at war or in the U.S.? So if y'all, my time's up, but if I could get answers to that question from each of you.
As quickly as you can, given the subject matter.
I don't believe he has authority to do that. They've cited things like hot pursuit, which makes no sense. It's not an imminent threat. I believe the president's kill list policy is flagrantly and dangerously unconstitutional.
I think it's quite a difficult question, but the Obama administration's Office of Legal Counsel memo on this is certainly quite strained. So they are reaching for analogies and analysis that is quite unconvincing, I'd say.
I am very, very far from an expert on these matters, but I would just offer one observation, and that is I don't really see why the American citizenship issue in the case that the Congressman is referring to is all that significant. I think that if a Nazi general happened to have been an American citizen, it wouldn't alter the way we could deal with it militarily. But there are weighty questions about the president's authority to implement the drone program. I don't really have an expert view on that.
Briefly,
I
Mr.
think it's been very effective militarily, so that is a good thing.
I'll just associate myself with Professor Turley's comments.
Okay, thank you very much. Appreciate y'all's testimony.
Thank the gentleman from Texas. The chair will now recognize another gentleman from Texas, Mr. Farenthold.
Thank you very much, Mr. Chairman, and I appreciate the opportunity to ask some questions here. And I'm going to ask for y'all's help in answering what's probably the #1 question I get at town hall meetings and people running up to me at the grocery store when I'm back home in Texas. And it goes something like this. And in light of, and you can insert whatever you want, Benghazi, Fast and Furious, the IRS targeting of advocacy groups, NSA overreach. If you like your health care, you can keep it. Varying the terms and waivers of Obamacare. the number one question I get is, what can you do about it? We sent you, Congress, to do something about this. And I've listened today, and I've heard, well, we can enact new laws. Well, that doesn't work if they can't get through the Senate and the President himself won't sign them. We can use the power of the purse. Well, that's pretty much dead. We've heard testimony about that. And in the era of continuing resolutions, we don't have a lot of options there. Well, we could go to the court. We've heard about the standing issue. We've also, even when there is standing, a delay tactic leaves you, probably the president will be termed out by the time any of these court decisions are held. We talked a little bit about elections. I think Chairman Issa brought up the issue, well, with the IRS scandal really interfering with elections, that's kind of off the table. And I'll admit my party didn't do as well as we probably should have in the other election, but we did do well in the 2010 election when historic numbers Congress changed. And then we've also talked about the I word, impeachment, which again I don't think would get past the Senate in the current climate. Am I missing anything? Is there anything else we can do, Mr. Turley?
Well, it does paint a dire picture. As we've said before, for years I've encouraged members to consider member standing as a standalone issue of trying to find a way to establish it either constitutionally or through statute to allow members of Congress to have.
Okay, so there's one fix to the court system, but you're still not going to get that through in any amount of time.
Yeah, to me the most troubling thing is I just published a law review article on recess appointments, which I also testified on. And we
forgot that one in the list of.
Well, what's fascinating about it is that because Congress has been stripped of more and more of its power, it has actually put more emphasis on appointments as a way of controlling the White House.
Have we been stripped of it, or have we inadvertently given it up?
I'm afraid it's either by a claim or it has been a
I want to get to the rest of the panel. Mr. Rosencrantz?
Well, I've said it before. I'm sorry to say that the ultimate remedy for this sort of thing is elections. And, you know, democracy is slow and messy. But at the end of the day, the right answer for this committee is to hold hearings like this, to publicize what it takes to be violations of the Constitution, and for that to become an election issue.
Mr. Lazarus, I realize you don't think we have the problem with the president a lot of my constituents have, but if I missed anything on a remedies against any rogue, and I use the term in broad general, not pointing to anybody in particular, a rogue president?
Well, I think that is, with all due respect, a gross misrepresentation of this president. And
now, I wasn't pointing to this president, a hypothetical rogue president.
Well, we know. We had a rogue president who was driven from office and who would have been impeached and convicted had that not happened. And actually, that result was guaranteed in this very room when the ranking Republican member of the Judiciary Committee voted to impeach Nixon. So sure.
Right. And Mr. Cannon.
Well, I think what Professors Turley and Rosencrantz said is accurate, or would help member standing. Yes, you have to win elections. Something that hasn't been mentioned is getting Democrats to care about this issue when there's a Democratic president, and getting Republicans to care about these issues when there's a Republican president.
And that's one of the things.
Right now, I don't know if anyone who's watching this at home has noticed, but all the Democratic members of the committee have left the room. I think they left like 20 minutes. We're 3.5 hours into this hearing. They're obviously not as interested in this as
And finally, I think one of our problems here is we have a president right now who is not willing to work with Congress. I think that's what we just had a Democrat walk in. That's not willing to work with Congress.
I retract my statement. My apologies.
I've talked to a constituent who worked for the Bush White House, whose job it was to lobby with Congress. And I've met with somebody from the Obama administration exactly twice in 3 years. And I do think it's the president's duty to engage. I had a question on that, but I'm out of time. But I do think there is a disappointment with the president not being engaged. Mr. Cannon.
But if I may, Republicans are very concerned about executive power when the executive is a Democrat. Democrats are very concerned about executive power abuses when the executive is a Republican. I think that the members of each party need to care about these issues a lot more when their own if someone from their own party occupies the White House and not just when someone from the opposite party.
Thank you. I see my time has expired, Chairman Gowdy. I'll give it back to you.
Thank the gentleman from Texas. Chair would now recognize the gentleman from Tennessee, Mr. Cohen.
Thank you, sir. I have obviously missed some of this hearing, although I've caught some of it on the magic of video, television. And I was interested, the gentleman from Mr. Cannon had mentioned the possibility of impeachment or some impeachable offenses. Is that accurate?
I can't remember if I brought that up. I may have.
And in what context would you have brought that up?
I think in response to a question. I'm not sure if I did or if someone else had mentioned.
Can anybody on the panel refresh his memory?
I think what I brought up was a constitutional amendment convention. I'm not sure. I don't think I brought up impeachment, but it's certainly I agree that it's certainly a tool that the Congress can use to restrain the executive.
Constitutional amendment. You suggested we should have some type of convention?
The question I was asked was, I was asked about ways of the Congress or the people can restrain the executive, and I offered that as one way.
That's never been done before, has it?
Not that I'm aware of, no.
Yeah. Anybody else on the panel have any thoughts about impeachment?
I mentioned impeachment earlier. We've been asked several times questions about possible remedies if we find that a president is behaving lawlessly. I've not said that this president has or that these examples rise to that level, but the ultimate constitutional check on a lawless president is impeachment and ultimately election.
Right, that's the check. But nobody's suggested that there's, the president's certainly not committed any impeachable offenses, I presume. Is it? Nobody here thinks that. Is that right? Mootness? You, Mr. Cannon?
Well, I don't know. As Professor Rosenkranz mentioned, I think an important element is that that whatever crimes or misdemeanors he's committed were committed knowingly, and whether there is a pattern of abuse of his office. And in my testimony, you'll see that I actually lay out a pretty consistent pattern whereby the President Obama has ignored and tried to rewrite portions of the Patient Protection and Affordable Care Act. And I think that the most egregious of these is the one where he is implementing the law in a way such that he is taxing and borrowing and spending over the next 10 years $700 billion that this Congress never authorized. Now, you may disagree with my interpretation of the law. I know Mr. Lazarus does, but I think that you and I and Mr. Lazarus would all agree that if a president were trying to tax and borrow and spend $700 billion without congressional authorization, that might be an impeachable offense.
Does anybody here think any of the actions of the Bush administration and going into Iraq without actual knowledge of weapons of mass destruction or anything else would have been a impeachable offense? Mr. Lazarus, you seem to be nodding.
No, I was just disregard the nod behind the curtain or in front of the curtain. I was very upset by that, but whether it's impeachable is a political decision that Congress would have to make.
Mr. Turley?
Well, the war powers issue does come closest for me for both President Obama and President Bush. The reason I don't think it rises to that level is because court decisions have made this field so much of a mess. First of all, by judicial passivity in not reviewing it, and by the use of historical practice. So I think it's very hard to maintain an impeachable offense when you have that degree of ambiguity. I don't believe that ambiguity is found in the Constitution. I believe that President Obama violated the Constitution in Libya, for example. But because of that history and that precedent, they can claim that they were acting on a reasonable interpretation of the law.
Thank you. Mr. Gowdy, I congratulate you, I guess, on South Carolina's victory, and I yield back the balance of my time.
Thank you, Mr. Cohen. I got to be careful how I respond to that since they're both state schools. I thank the gentleman from Tennessee and will now recognize another gentleman from Texas, former judge, Judge Poe.
Thank the chairman. I disagree with you, Mr. Cannon, on that Republicans are only concerned about executive abuses when Democrats are in control. I personally don't like any executive abuses, no matter who the president is. And I think our executives have gotten out of control over the last several executives, not to mention the judicial branch, which I served in for 22 years. I think it has exceeded its boundaries of the Constitution. But we're talking about the executive branch. In the Constitution, if I remember it correctly, the executive branch is mentioned second. The first one mentioned in the Constitution is the legislative branch. That would be Congress. Third is the judicial branch. My understanding of the writers of the Constitution, they put the most important one first and the least important last, because we're elected and the guys on the other end are appointed forever. In the middle is the executive branch. The President has said we are not a banana republic. There's a lot of definitions to banana republic, but my view of a banana republic is a lawless country. We are proud of the fact in the United States we are a country of laws, not people. But yet, we are in a situation where the law means different things to different people, and it isn't enforced. And like many have said here, back home in Texas, they just don't understand where the president gets the authority to do some of these things without congressional intervention. I agree with the people that I represent. And they're from both parties. They're not just Republicans. They're saying, well, how can he do that? If I hear that once, I hear it 100 times when I go home on weekends. How can he do that? And what are you going to do about it, Congressman Poe? I get asked that a lot. We've had some discussion about those things. We know the subjects. There are a lot of subjects where people question whether the president has authority. But let's spend one moment on one issue. Obamacare, according to the Supreme Court, is a tax. The president has used the law and has said that I'm going to postpone that tax for this group first, big business. Then I'm going to postpone the tax for 6 weeks for individuals. And then I'm going to postpone the tax a year for small businesses. He's postponing taxes. Since I have no life, I have read Obamacare. I don't see that in there where the president, we gave him the authority to postpone a tax, but he does it. Now, if he has the legal authority to do that, which I doubt, but he used that authority, what is to prevent him from just going and looking at the IRS code, which is a mess? I don't know any American that thinks the IRS code is a good bill. But rather than fix it, we just make it bigger every year. So the president goes to the IRS code and says, well, this group of businesses, they're just having a bad year, like green businesses. Or we could use the energy companies on the other end, those oil and gas industry. I'm just going to postpone them paying income tax for a year. Why? Because I said so. Or I'll take this group and do something similar. Tweak their tax. Rather than paying 38%, they're going to just pay 20% for the next year. It seems to me if he has the legal authority to amend taxes, which the Affordable Health Care Act is a tax, according to the Supreme Court, what is to prevent him from just amending any tax to his liking? Mr. Turley, weigh in on this, if you would, Professor.
Thank you, Congressman. I have to agree. First of all, on your first remark about Article 1, you know, as I've said before, it is true that they're all equal branches, but the framers spent the most time on Congress because it is this thumping heart of the Madisonian system. It's where the magic happens, and that magic is to take those factional interests, those interests that destroy countries, and turn them into majoritarian compromise. And when we get to the issue of taxes, as you've raised, that's one of the most divisive issues facing a country. And so when someone comes before Congress and says, I want my group to be excluded, it obviously produces a great deal of heat from people saying, well, how about my group? How long should this apply? It is perhaps the most divisive issue that is raised in Congress. And that's precisely why it was given to Congress, so that those types of issues would be subject to this transformative process of legislation.
So do you believe that that would be an unlawful constitutional act if the president started amending the tax code on his whim?
Yes, I do.
Let me ask you one other question, if I may, Mr. Chairman. You've mentioned remedies. What about the remedy of a mandamus? Would a mandamus remedy lie in any situation where Congress thought the executive had not enforced the law?
Mandamus can be very difficult in some of these if you're trying to use mandamus against the president, but you can challenge some of these decisions. For example, the HHS decisions is violating APA, for example. You can go with if you have standing to do so. Those are long, obviously a long process. And this is one of the things where I tend to get off the train with at least one of my colleagues. This is not an APA issue. This is a constitutional issue. It's a president usurping the authority of Congress. And to say that this is just something that we leave to agencies, I think radically misunderstands the severity of the situation.
Thank you, Mr. Chairman. I yield back.
I want to thank all of our witnesses for an excellent hearing, a great discussion on what I think is one of the most important issues facing our country today. I want to also thank the members for a very strong participation in today's hearing, and that means the witnesses had to stay maybe a little longer than they had originally thought they would, but that only means that you've had the opportunity to talk through and think through and debate this issue even more extensively. So I thank all of you for your participation. This concludes today's hearing, and without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record, and this hearing is adjourned.
Thank you. Good job.